Welcome to a Legalbytes presentation of the Karen Read murder trial. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. If you want more on the background of the Karen Read case, check out our video on it linked in the description below. But otherwise, you be the jury. Did Karen Read murder her Boston PD boyfriend John O'Keefe, or is she being framed by local police who Read says are actually responsible for O'Keefe's death? Tell us what you think. But in the process, the one rule is don't be a dingus. Remember, everyone comes from their own perspective and opinion, and everyone comes to conclusions at their own pace. Agree or disagree, but always respectfully. Okay, let's get into it. All right, folks, and welcome back to another day of testimony. Apparently, it's going to be a full day of testimony, despite the fact that we've got, it's a Friday. It's a Friday. Originally, of course, Judge Canone had set the schedule to be Mondays and Wednesdays are full court days, Tuesdays and Thursdays are half court days. And today, Friday, would be neither. That would be a day basically reserved for the attorneys in the case to argue motions over evidence and other kind of stuff like that comes up. So, yeah, but we are back. We are back in trial, and I don't know why we went back to the fan, but apparently we did. So, they showed the judge walking in just a minute ago. And then I think they had a bit of a long sidebar. So they were talking and chatting. I guess the jury wasn't there yet. Maybe they are waiting for the jury at the moment. But what a trial, right? What a trial. It's been very interesting. Showing the fan once again, just to make sure you guys, in case you don't believe me, what's going on. But this trial has been fascinating. Yesterday, I guess a little bit of a recap, while the actual recap that I filmed is uploading, should be a couple hours from now that it will be published, unfortunately. So what time is it now? It's a little past 9, so it'll be a little past 11 when that goes up. So during the lunch recess, you guys can watch it if you have a chance. But otherwise, yesterday was Christopher Albert and Julie Albert, witnesses number 23 and 24 for the Commonwealth of Massachusetts. And those were definitely a slog, I think that what the prosecution wanted to get out of them may have had more to do, the more I thought about it, it may have had to do more than anything with Colin Albert and some of the allegations that they probably anticipate are coming out from the defense about him. It seemed that yesterday, one of the most important things to come out was the timing of Colin Albert getting back home. The Albert parents were saying,
"You are unmuted."
Aha, I guess we're about to see the jury coming in. So apparently, let me finish this up. So apparently the Albert parents, the Julie Albert and Christopher Albert, were indicating that
Hear ye, hear ye, hear ye, all parties having anything to do before the Honorable First Justice Beverly Canone, now sitting in the Dedham Superior Court within and for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth in this court. Thank you. May be seated. Morning, Your Honor.
Morning.
Okay, I'm going to pause it really quick because I love that accent. And by the way, just as a side note, I know this is a total interruption from what I was just saying. I'll get back to it, I promise. But, every day when I do the what if any lolly tally, which I will get to before we start the testimony also, so the way that I do it is for every live stream, I have a plugin for YouTube that is like an AI transcript grabber, basically. And so I grab the entire transcript and I copy it over into a Word document, and then I copy it into a PDF and use that to give a visual for the search for if any, so that it's what if any. And so anyway, so I always hear that, like, that's like the first thing that I see on the transcript is the hear ye. But the transcript grabber does not understand a Bostonian accent. So the transcript always says, like, like Heyeye, like hey ye. It's really funny. It doesn't understand it. So so it cannot translate the accent from the Bostonian area, which is just absolutely delightful. I always get a chuckle every single time I see that as I'm pulling up the what if any lolly tally. Speaking of which, yesterday I've got it already on Twitter. It's all there. So if you follow me on Twitter, you already have seen it. But the lolly tally for yesterday. So going into yesterday, it was at 5. No, hang on. It was at 6:49 going into yesterday. Yesterday was a shorter day, and there was a lot of cross-examination by the defense. So it was a smaller number. Actually, the smallest number that we've had yet, it was 49. Only 49 what if any's. Only 49. Can you believe it? Only 49 what if any's yesterday. So the total now going into day 9 is 698. We are creeping up towards that first 1,000. I feel like we should have a celebration when we hit 1,000 what if any's, which won't be long, guys. It won't be long. It'll be sometime next week for sure. So anyway, as I was saying, the parents of Christopher and Julie Albert, it seemed like what they were testifying to was that Christopher Albert got home about 12, not Christopher, sorry, Colin Albert, their son, got home at 12:20 a.m. because they were initially the testimony was Christopher Albert got home at 12:10 a.m. His son got in 10 minutes after him, maybe 15 minutes. So 12:20, 12:25, basically before 12:30. That sounds like, so from what I understand, the timing of what happened, what's alleged to have happened with Karen Reed is that she swung by 34 Fairview Road at 12:30 a.m. and that's when John O'Keefe got out of the car, and that's when she ran over him. That's the allegation. That's the timing of the allegation as far as I understand it. Now, if the prosecution lays something out that's different, then we'll go with that because we're going to go with the evidence as it comes out. But that's my understanding of what they've alleged so far. So there's something about Colin Albert either being there or not being there at 34 Fairview Road. And I think that part of it has to do with him walking out of 34 Fairview Road, and he would have seen John O'Keefe if he was lying there in the snow at the time that he walked out. I think it has something to do with that, but I don't know for sure because, a lot of these details, I'm taking it as we encounter it, similar to the jury. I know some background, enough for the primer video that I made, but I admittedly don't know all of the nitty-gritty details, but I'm looking forward to seeing all of them play out. But there definitely was something interesting about that. And yesterday's cross-examination of Christopher Albert in particular really went through the nitty-gritty details about what time Christopher Albert left the Waterfall Bar and Grill, which was 12:13 or 14 a.m. Took him about 7 minutes to get home. So, 12:19, 12:20. That means, and then getting upstairs and all that. So it sounded like more like Colin Albert got home at 12:35, 12:45. So that the defense is definitely playing this so that Colin Albert came home later than what the prosecution is initially saying. So anyway, that's something that I anticipate we'll be seeing a bit more of. And we did not finish the cross-examination of Julie Albert. And remember, at the very end of the day, the cross-examination ended with this whole, I call it the Julie Albert connection, because it's this idea that maybe she's been a mediator between the Albert family and the Proctor family, specifically kind of between Brian Albert and then Michael Proctor, to be sort of a bit of an undercover liaison between the two, with all of these extra phone calls that suddenly she and her friend Courtney Proctor, Trooper Michael Proctor's sister, all of a sudden they started calling each other when previously their what's the word? Well, their practice was to text each other. So that's what things are sounding like going into day 9. We'll see where the cross-examination goes, and when it picks up, we'll see. So that should be happening about now. So let's get to it, shall we? As always, questions in the chat. I will be I will be watching for them and saving them and trying to answer them in the moment if it requires it. If it's about like objections and things like that, I'll try to do that. Other than that, we will we'll get moving, shall we? And let me know if there's any issues with the volume. Unfortunately, if the attorneys are not talking into the mic, I can't control that. But otherwise, I've already got sound boosted, so hopefully everything's good. Okay, folks, let's get into it, shall we?
All right. Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. Happy Friday. I appreciate you all being here, ready, willing, and able to start. We got an awfully lot done in about 5 or 7 minutes over here at Sidebar. So we made you wait, but in the long run, we'll speed things up and we'll make things go more smoothly. So we appreciate your patience. Those same 3 questions, have you all been able to follow the instruction and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you all able to follow the instruction and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday?
No.
One thing I did want to say to you folks is if you can't hear a witness or a lawyer or you can't see something, I don't know that unless you raise your hand. So if you raise your hand, the court officers don't have the power to say to the witness, please answer that again and speak louder, but I do. So if you raise your hand, court officer will come over and let me know and we can make sure that happens. All right, so I remind counsel to keep their voices up, and you've been doing a great job of moving out of the way of the jurors toward the end there. So
Yes, please keep your
continue to do
voices
so.
up, and maybe the jurors can
All
start
right,
raising their
is Ms.
hands
Albert here?
when the attorneys are talking. I would, yeah, we would all appreciate it if the attorneys would speak up. The witnesses are doing a great job so far. All right.
Thank you.
I think this is Julie Albert again. Yes.
The evidence given to the court and jury in the case now here and the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Okay, I'm just going to remind you, keep your voice up, please, Ms. Albert,
I will.
okay? All right, Ms. Giannetti?
Thank you, Your Honor. Good morning, Ms. Albert.
Good morning.
Ma'am, you will recall yesterday, I broached the topic with you of how often you and Courtney Proctor speak to each other over the phone. Do you recall that line of questioning?
Yes.
And when I asked you to describe the frequency of those phone calls, I didn't put any words in your mouth, did I? I didn't suggest how frequently they were. You came up with the word.
I don't really.
Well, let me put it this way. When I asked you how often you talked to Courtney Proctor, you could have chosen any word in the English language to answer that question, correct?
Correct.
What was the word that you chose?
Rarely.
Not often. I don't remember,
How about
honestly.
rarely?
Rarely. Yes.
That was your word, correct?
It could have been. I don't really recall. I don't recall.
You don't recall telling.
Okay, come on now. You don't recall your own testimony from yesterday. We all recall you saying rarely. We all recall that. Everyone watching recalls that. So come on. It doesn't help you. It doesn't help you when you're doing that because you'll look shady. Girl.
In this jury yesterday that when I asked you about how often you spoke to Courtney Proctor by phone, you said, well, rarely.
I don't remember.
What is your definition of rarely?
See, with that response, like I almost I feel like I have a temptation that I would want to go down the road of being like, okay, is there an issue with your memory? But I don't. I feel like that would be unwise on cross-examination because I think the jury's going to be thinking that the jury's going to see right through that. Well, if they are, as skeptical as I am right now of this testimony, they see right through it. But so, the attorney doesn't need to go down this whole road of like, do you have memory problems? Have you had any diagnoses for dementia or Alzheimer's or anything like that? But maybe, but it it looks like she either has a memory problem or she has a convenient memory problem when it doesn't suit her.
Not daily. Not daily. Not.
Them
Yes.
once in a blue moon?
No.
Rarely doesn't mean to you 67 phone conversations within a 7-month period, does it?
A 67 time period in how many? 8 months?
In about 7 months, 67 times.
It's not a lot. I wouldn't think it's a lot in 7 months.
3 times in one day? Is that rarely?
No, but I'm not. That wasn't every day. I would.
Okay, well, when you left the stand yesterday, did you log into your account or check any old bills to confirm those 67 calls?
No, I did not.
Did you speak to Mr. Lally about those 67 calls after we broke yesterday and before you took the stand today?
I don't believe so. No.
What do you mean you don't
Call
believe so?
Courtney
It's yes or
Proctor
no.
in one of those rare occasions? Yesterday?
No, I did not.
This morning?
No, I did not.
Were you curious as to whether or not you had actually called her those 67 times?
Objection.
Sustained.
All right. In any case, regarding all of those 67 phone calls from February 1st until September 6th, do you maintain that during none of those calls or any portion of those calls did you and Courtney Proctor discuss the investigation into the death of John O'Keefe?
I do not remember.
Do you deny discussing that investigation?
I don't deny, but I do not remember.
All right. Well, you admitted yesterday, after having seen the records, that you spoke with Michael Proctor's sister for 12 minutes on February 1st of 2022. Do you recall that?
I don't recall the conversation. No, I don't. It was a long time ago.
I'm sorry. I don't mean to interrupt you. Finish your answer.
I'm sorry. It was a long time ago. I just don't remember.
Okay. But my question is, after seeing the records, you saw the phone call for over 12 minutes, correct?
Correct.
And you also remember that that was the very day that the police arrested Karen Reed for this case, correct?
Correct.
The arrest of Karen Reed on February 1st was pretty big news in Massachusetts, correct?
Objection.
Sustained.
You had seen that arrest all over the news, correct?
Correct.
So you certainly, given the day and the fact that it was February 1st and my client was arrested that day and you're talking to the lead investigator's sister, the subject of Karen Reed's arrest had to have come up, right?
Objection.
Sustained. Ask it differently.
You certainly mentioned my client's arrest with Courtney Proctor on the very day that she was arrested and you were talking to Courtney, correct?
Correct.
Now, when we broke for the day yesterday, I had also asked you about the 3 phone calls that you had with Michael Proctor's sister on the morning of February 2nd when my client was arraigned, correct?
Correct.
And you recall that her arraignment was televised publicly, correct?
Objection.
Sustained. Ask it differently.
You saw her on the news being arraigned, correct?
Correct.
And one of those phone calls after, well, strike that. With regard to the 3 phone calls before the arraignment, you knew at that time that my client had been arrested the day before, correct?
Correct.
And you knew she would be arraigned in court that morning, correct?
Correct.
Certainly, when you were talking to Michael Proctor's sister on February 2nd, before her 9 o'clock arraignment, you were discussing the 9 o'clock arraignment, correct?
Can you repeat the end of that, please?
Sure. On February 2nd, the day that my client was scheduled to be arraigned in Stoughton District Court, we're talking about the 3 phone calls that you made to Michael Proctor's sister before that arraignment that very day. And my question is, certainly you were discussing the fact that she was about to be arraigned, correct?
Objection.
Sustained. Ask it differently, Mr. Mayor.
So the reason why he's getting sustained on all of these is because he's asking about out of court statements, about things that were said. What were they talking about? What was Courtney Proctor talking about? So these are statements that are, I believe, not coming in because of the hearsay exception or hearsay, the rule against hearsay.
Did the subject of Karen Reed's arraignment come up in any of those 3 calls on February 2nd, the day she was going to be arraigned, before her arraignment?
I don't remember exactly.
What about the 27-minute phone call that you had with Courtney Proctor at 10:58 a.m. that same day after my client was arraigned in court? Did you discuss the arraignment that had just happened?
I do not remember.
You had already testified that by 2022, you were no longer babysitting for Courtney Proctor's kids. Correct?
I wasn't babysitting regularly like I was before.
So is it your testimony that you happened to be talking about babysitting on February 2nd for 27 minutes, the same day that my client was arraigned in Stoughton District Court?
I don't remember what I was talking about. It could have been about the kids. It could have been about anything. I don't remember.
If there's a gap between these 2 phone calls, they're on the same day, and the gap is conveniently like it's the televised arraignment of Karen Reed, and that just lines up perfectly with like the beginning and the end. Like that sounds like they were on the phone talking about it. Then it comes on TV and they're like, oh, we got to hang up. We got to watch this thing. And then as soon as it's over, one of them calls the other one back again and is like, okay, let's talk about all of this and gossip about it. Like that's the vibe that I'm getting from all of this. And she does not want to be admitting to any of it. She does not want to be admitting to any of it, which, you know, again, like when it comes to good facts, bad facts, you know, there are always going to be bad facts for basically for every witness. Just, you know, imagine every single witness has something about their testimony, something about their experience that is not going to be necessarily good for the case that they are testifying for. The way that you get ahead of it is, you get really comfortable with those bad facts. You get really comfortable with talking about them, explaining them, you know, giving your perspective on them and just facing them. Because when you answer, when it comes up on cross-examination and, you know, you're being grilled about something that is perceived as a bad fact for the side that you're testifying for, you know, he or she's being called by the prosecution, you know, it looks a lot worse for you if you try to sort of hide, if you sort of, you're cringing, you're crumbling, you know, it looks a lot worse. It looks a lot worse. If you are, on the other hand, just upfront about it and you say, yeah, we were talking about it. Who wasn't? That takes out some of the air from that balloon. The other thing that takes out air from the balloon is if it comes up initially on direct examination. That's actually the best way for it to happen. And this has happened multiple times in this trial. So this is another complaint that I have about the prosecution is them not anticipating bad facts coming out about their witnesses that are being put on the stand, so that whenever this stuff comes out on cross-examination, it's so much worse. It's always worse coming from the other side. You got to take the sting out of the bad facts by bringing it out yourself, addressing it head on, and then you have an opportunity to explain it away on direct examination in a friendly environment. So this is, you know, a little bit of like trial strategy here, but you know, right now she's really, really, really trying to keep her head above water with this cross-examination.
And certainly it could have been about the publicly televised arraignment that had just occurred, correct?
Objection.
So I'll allow this and then let's move away from this, okay? Can
It-
you answer that?
Yes, it could have been. Yes.
Did you tell Courtney Proctor during any of these 67 phone calls that you were a witness in her brother's case?
I don't remember.
Okay. Ms. Albert, you were at the waterfall on the night of January 28th, correct?
Yes.
And you also went to 34 Fairview on the morning of January 29th.
Yes.
Yet, as of the date of these phone calls that we've discussed so far, the February 1st and the February 2nd, multiple phone calls, Trooper Proctor still had not interviewed you, correct?
Correct.
You were finally interviewed by Trooper Proctor on February 10th, about 13 days after John O'Keefe was found dead on Brian Albert's lawn, correct?
Correct.
And you told Courtney Proctor that you were nervous to speak to her brother, Trooper Proctor, about this case. Do you remember that?
I do not remember those exact words, no.
All right. But you were nervous to speak to him, correct?
Of course, I was nervous in general for a police interview. I mean, I don't know someone who wouldn't be.
Were you worried that one of Trooper Proctor's colleagues might ask to speak to your son, Colin, about what had happened on the 28th and the 29th?
Oh,
Objection.
Was I nervous they would ask my son?
Yeah, were you nervous that one of the investigators in this case might approach your son to ask him about his whereabouts?
No.
All right. In any case, you were interviewed at 5:30 p.m. on February 10th, correct?
Correct.
Where did that interview take place?
At my home in Canton.
Who was present for that interview?
Me, my husband, Trooper Proctor, and Trooper Bukaki.
I don't think that's his name. I think that means something else that she doesn't
Michael
intend.
Proctor agreed to interview you and your husband together, correct?
Objection.
Sustain.
I think it's Buchanan.
You and your husband were interviewed together, correct?
Correct.
Did either of these troopers, including Michael Proctor, suggest that maybe the two of
Yeah, guys, that was a really big slip in this trial. She definitely got his name wrong in the worst way. I can only imagine Emily Baker's chat must be going absolutely insane. Oh, that poor trooper. I mean, we haven't seen him testify yet, so maybe not poor trooper. But hang on, let me check the witness list to see what his name actually is. I think it's Buchanan. Oh, wait, hang on. Yeah, Buchanan. Sergeant Yuri Buchanan. Oh, that poor guy. You know what? Those of us with ethnic names, we sometimes have a hard time. But that oh, that was a bad one. That was a really bad one. Okay. Yeah, I hope the video doesn't get flagged. I mean, I'm not gonna keep saying it, but like, yeah, Matthew Baxter. Yeah. Okay. All right, you guys. Let's. I'm gonna go back 5 seconds because to revisit like what she's actually saying. I was kind of laughing over it, but let's keep moving. Oh, we're 12. We're not 12. We're 12. We're adults, right? we're adults.
Either of these troopers, including Michael Proctor, suggest that maybe the two of you should be separately interviewed?
I don't recall.
Where
I don't
did the
remember.
interview take place within your home?
In my family room?
Were you sitting on couches?
Yes.
You're comfortable?
Yes.
You were not in a police interrogation room, correct?
No, I was not.
And it wasn't particularly lengthy, correct?
What do you define lengthily? I don't recall. I don't remember how long it was exactly.
It didn't go into the evening, correct?
No.
And then Michael Proctor and the other trooper left, correct?
Correct.
Then at 6:17 p.m. that same night, shortly after you had been interviewed, you called Michael Proctor's personal cell phone number, correct?
I don't remember.
Let me have a moment.
Okay.
You didn't bring your cheaters today. Oh, you did? Good. Okay. May I approach you on?
Yes.
This is the same document. I'm going to hand you one document. There's an orange sticky on it that you can ignore.
Okay.
But right above the orange sticky, there's a date of February 10th. That's what I'm directing your attention to. You could look at those 2 phone calls, ma'am, and look up at me when you're done. If I may approach.
Yes.
Did that refresh your memory about those 2 phone calls on February 10th?
I mean, I just read them, but I don't remember.
Okay. You called Trooper Proctor at 6:17 p.m. and it appears to be a 5-second phone call. Did you see that?
Objection, Your Honor.
Sustained.
Do you recall that Trooper Proctor called you back that same day at 6:21 p.m. and that you spoke for about 4 minutes?
Objection, Your Honor.
Sustained.
Do you deny speaking to Trooper Proctor for 4 minutes when he called you from his personal cell phone on February 10th of 2022 after you had been interviewed that day?
No, I don't deny it, but I don't remember it.
When did you get his personal cell phone number?
I don't remember.
Years ago?
I'm sure, yes.
Because you've known that family for a long time.
Yes, I have.
And as you testify here today, you can't remember what that phone call would have been about, correct?
No, I do not remember.
Okay, I'd like to contrast your relationship with Karen Reed versus your relationships with Jennifer McCabe and Courtney Proctor. You would agree with me?
Sorry, my mic was muted because I still was having a giggle fest. But what I said while muted was it just came out of nowhere. It just materialized in her phone. Who knows where it came from?
I think you testified yesterday that Jennifer McCabe is one of your best friends,
Correct.
and you call her Jen, correct?
Yes.
And Courtney Proctor is also one of your best friends, correct?
She's not one of my best friends. No, she's a good friend. She's not one of my best friends. No, she's my sister's best friend.
Gotcha. Okay, so your sister,
My sister Jillian. Yes.
Jillian is best friends with Courtney Proctor, and you're close friends with her, but not best friends.
Correct.
But you really only knew Karen Reed as John O'Keefe's girlfriend, correct?
Correct.
She was just an acquaintance of yours.
Yes.
There are no photos of you in a hot tub together, right? You and Karen Reed?
No.
There are no photos of you with your arms around each other at the beach, correct?
No.
You've never been to a baby shower with Karen Reed, correct?
Objection, Your Honor.
Sustained.
You didn't have any contact with Karen Reed while you were growing up, correct?
No.
Karen Reed was definitely not from Canton, correct?
Objection, Your Honor.
I'll allow this and then you can move on.
No, she was not.
No, one more question. She was an outsider, correct, to Canton?
She didn't live in Canton.
But after she started dating John, you would see her driving in and out of the street, correct?
Yes.
You'd see her taking groceries in, correct?
Yes.
Because you were neighbors with John.
Yes.
And it was the fact that you'd see her around, taking groceries in and out of the house and being outside with the kids that led you to believe that she was not only connected to John, but also to his house on Meadows Ave, correct?
Yes.
And you would see her interacting with the kids outside, correct?
Yes.
She would be participating in family type activities with the kids outside.
Yes.
And you'd see her enough that you assumed that she was living there, correct?
Yes.
And I believe you stated that you had known her or seen her for maybe about a year and a half or so. Is that a good estimate?
Yes.
And in all the time that you saw her in the neighborhood or had any contact with her and John, you never saw the two of them fight or argue, correct?
No.
You never heard them fight or argue, correct?
No.
And you had been out with them in a group setting a handful of times, correct?
Just a couple of times.
And during those times, they always appeared to get along, correct?
Yes.
And you knew of no problems in their relationship, correct?
No.
And you were particularly impressed with the time Karen spent with John's adopted children.
Objection.
Were you?
Can you repeat that once more, please?
You were impressed with the amount of time that Karen spent with John's children.
I didn't know the exact really amount of time she was there a lot. Yes. She was, so yes, I would assume that she spent a lot of time with them. Yes.
Now, on Friday, January 28th, you had plans with your sister-in-law, Nicole, correct?
Yes.
You are close with Nicole.
Yes, I am.
You picked her up at her home in your car.
Yes.
You drove her to the waterfall, correct?
Correct.
And the two of you went for dinner there.
Yes.
Your husband, Chris, came later.
Yes.
Brian Higgins came later.
Yes.
And you knew Brian Higgins, correct?
Yes.
Mr. Nanney, I'm going to stop you for 1
Yes.
second.
I'm still feeling really bad for Trooper Buchanan. Justice for Trooper Buchanan. Oh man. Okay. I promise I'm done referring to it.
I believe you testified that you knew Brian Higgins at that time, correct?
Yes.
And how did you know him?
He is a friend of my brother-in-law.
And your brother-in-law would be Brian Albert, correct?
Yes.
And by the way, when I just asked you that question about how you knew Brian Higgins and what his relationship was to Brian Albert, you didn't hesitate to say that they were friends, correct?
Correct.
It was very clear that they were friends, correct?
Correct.
In fact, the two of them arrived at the bar together, correct?
Yes.
And it didn't surprise you to see the two of them together, correct?
No.
Karen and John came sometime after that,
I believe shortly after that. Yes.
and they walked over to your table.
Yes.
And then John kind of came up from behind you and sort of in a joking way, dug his finger into your shoulder
Correct. Yes.
and essentially said, what's up? And that was about it. And he went on, correct?
He said, "What's up?" and made a joke. And
And the joke was, given the fact that you and your husband moved from the neighborhood, they decided to hold a block party. Correct?
yes.
And John was the same jokester he always was, correct?
Correct. Yes.
And you had some contact with Karen while you were at the bar before you had to leave because of the migraine, correct?
Correct.
And she was just very bubbly that night, correct?
Correct.
That's just her personality as far as you could see, correct?
As far as I knew, yes.
You didn't know her that well, but that's how she always was, correct?
Correct.
And you left the waterfall at around 11 o'clock, your best memory?
A little after 11.
And it was a particularly bad migraine that night?
Yes.
And the loud music didn't help you out at all?
Not at all.
And you drove home?
Yes.
Now, when you got home, your son Colin was not there, correct?
Correct.
He was not out with you at the waterfall.
Correct.
He was out that night, correct?
Yes.
And you knew that he stops by your sister-in-law Nicole's house quite a bit, correct?
Yes.
He's very close to Nicole and Brian's kids, correct?
Correct.
He's also very close to his aunt and uncle, Brian Albert and Nicole Albert, correct?
Correct.
So you would have gotten home maybe shortly after 11:10 p.m. approximately?
Around 11. Yep. Around that.
And that was when you entered an empty house, correct?
My son Dylan was home.
Oh, Dylan was home.
Yes.
But Colin was not.
He was not.
And Colin did not come home at 11:30, correct?
Correct.
He did not come home at 11:45, correct?
Correct.
And when the clock turned midnight, he still wasn't home, correct?
Correct.
Now, at some point, your husband Chris came home, correct?
Yes.
You testified on direct examination that Chris came home at 12:10 a.m. on January 29th.
That's what time I believe he did. Yes.
Okay. That 12:10 a.m. time. Did you discuss that precise time with anybody prior to taking the stand yesterday?
Uh-oh.
No,
Was that coordinated with anybody such that your husband and you gave the same time of 12:10 a.m.?
no.
With the court's permission, I'd like to play the waterfall Gully video. I think it's exhibit 53, just that portion. 12.
I wish I had a body language expert on with me to point out her face right now, because I kind of feel like she's holding in something there. I don't. That's how it looks to me. I'm not trained in any of that kind of stuff, and I know it's not an exact science and whatnot. But like, she looked incredibly uncomfortable when asked that. Incredibly uncomfortable.
Okay.
I know. I would love to have Spidey on for this. But she's trying to hold her face very, very still.
We may just have a moment, Your Honor.
Because 12:10 a.m. is the same exact time that both of them gave for when he got home.
I'm going to allow my colleagues some time to find this, and I'll move on with my questioning in the meantime. We can have the lights on again. Now, I believe you've testified that the waterfall is very close to D&E Pizza, correct?
Correct.
But your house on Maple Street is about a half mile away from the waterfall. Would you agree with that?
About that, yes. Maybe a little less, but about that.
All right. Would you agree it's a 7 or 8 minute walk home from the waterfall if you're walking? I realize you were driving, but
If you're chasing it, it might be a little bit faster.
Maybe a minute or two less.
Okay. So you would say 6 or 7 minutes would be a better estimate to cover that half mile?
Depends on how fast you walk, yes.
And it was snowing that night, correct?
Correct.
The ground was a little bit slippery.
Yes.
If I may just have a moment. If I could have the lights dimmed again. This is the exhibit I'd like to show you, ma'am. And if you can pause for 1 second. Do you recognize what's depicted in that video? Does that appear to be the waterfall?
Yes.
Okay. And do you see the time? Do you see the time, 12:13 a.m.?
Yes.
Okay, if you could run that, Mr. Bates. Can you pause it there? I am going to direct do you see where it says CH3?
Yes.
And you see the timestamp up the top, correct?
Yes.
Between those two markers on the video, you're going to see somebody walking by. I'd ask you to pay attention for the next, 6 seconds or so. Right. Stop. Do you recognize that person?
Yes, I believe it's my husband.
Okay. If you can run that. Stop. Okay. Would you agree with me that your husband left the waterfall at about 12:13 and 46 seconds?
Well, yes. I mean, that's what it says on the screen.
Okay. So it was closer to 2:14 than to 2:10. Would you agree with that?
12:14, you mean? Two?
You know what, you're right. 12:14 than 12:10.
Yes, that's what I'm seeing.
Thank you. So if he's leaving at around 12:14, and by your testimony, it would have taken him he was walking home, you knew that, correct?
Yes,
Yeah, he didn't have a car that night.
he did not.
And if it took him 6 or 7 minutes to get home, and by the way, let me strike that question. You had said it takes 6 or 7 minutes. Did you factor in the fact that of the weather that night for your estimate about a 6 or 7 minute walk?
Objection.
Can you answer that question? Is that what you said?
Yes, I didn't factor in the, I don't know.
All right, so your testimony
Falls
would be,
apart.
You don't know if it would have taken him a little bit longer, or anybody.
Anybody, everyone walks at a different pace.
Right, but whatever pace they walk at,
Mhm.
Given what you saw of the weather that night, is it your testimony that maybe it would have taken a little bit longer than the estimate because
It
of the
could
weather?
have.
Okay,
I
but
don't
in
know.
any case, let's leave it at 6 or 7 minutes. That puts your husband coming home at around 12:20 or 12:21, correct?
Correct.
All right. And that 12:10 estimate that you had, you made that estimate before having the benefit of the video, correct?
Correct.
Now, where were you within the house when your husband came home?
In my room,
Bedroom?
upstairs in my bedroom.
All right. And you share a bedroom with your husband.
Yes.
And when was the first time that you saw him within the house?
He came up to the bedroom.
Okay, so you were in the bedroom and you see him appear in the bedroom.
Correct.
Did you hear the door open way down on the first floor?
Yes.
Okay. And it would have taken him maybe about a minute to get upstairs. It wasn't very long?
It wouldn't be very long, no.
Okay. And when he got upstairs, you noticed that he was in wet clothing, correct?
Yes.
He appeared to be cold.
Yes.
And he got undressed, correct?
Yes.
Did he brush his teeth before bed?
I think he got right into bed.
Okay, so you didn't see him brush his teeth or wash up.
No.
And
What a
were
maniac.
you
Who does that?
in the bed
I
when
can't.
he came into the bed to go to sleep?
I was sitting up in bed, yes.
Were you reading or watching TV?
I was just sitting up in bed praying for my headache to go away.
Oh, okay. The migrine was still really
Yes.
bothering you, and you were suffering at that point.
Suffering? I had a headache.
Well, yeah, but a migraine headache, I would
Yeah.
imagine.
It was a headache, but I took medicine and I was waiting for it to get
waiting for
better.
it to kick in.
Yes.
Okay.
I thought she initially testified that she had already been like sleeping and that she like was tossing and turning maybe because of the fact that her son was still out. I thought she said she was sleeping. Maybe I got that wrong from yesterday, but that's what I thought.
And that's sort of what you were concentrating on. It's really kind of hard to read or watch TV or concentrate on anything when you have a migraine, right?
Okay. Yes.
Now, you would agree with me that your husband Chris was asleep when Colin came home, correct?
Correct.
Thank you, LaQuaria. That makes sense.
And as a mother, you couldn't have gone to sleep until you knew your kids were home, correct?
Correct.
And Colin was the remaining child who was out there, which when he came home, that would given you license to go to sleep.
Yes.
Now, at the time that Colin came home with Chris sleeping, it's fair to say this was just an ordinary weekend night, correct?
How do you?
Well, in other words, you didn't know that anything tragic had occurred or was alleged to have occurred, correct?
Correct.
So it wasn't like you were paying attention to the clock at that point and recording your memories as best you could because you knew you'd be testifying later, correct?
Correct.
Which also explains the 12:10 estimate, right? I mean, you're being asked about, times that things occurred, and it was just sort of an ordinary day, right? So it's difficult to pinpoint times, correct?
Correct.
Okay. Now, directing your attention to the next morning, you missed a phone call from your best friend, Jennifer McCabe, correct?
Correct.
And you believe that phone call, I think according to your memory, yesterday came in at 5:55 p.m., correct? I'm sorry, 5:55 a.m., correct?
Correct.
That was the time that you gave Mr. Lally when he asked you the question on direct examination, correct?
Correct.
And you were able to recall that time nearly 2 years later, correct?
Yes.
But regarding the 67 phone calls between you and Courtney Proctor that happened after that, you're not able to recall any of those, correct?
I just don't remember them.
Of course not.
All right, in any case, January 29th was your nephew Brian Albert Jr.'s birthday, correct?
Yes.
That's why you went to 34 Fairview at 8:30 in the morning, correct?
Yes.
And when you pulled into the driveway, there was nothing unusual to you, correct?
Correct.
This was just your brother-in-law Brian and your sister-in-law Nicole's house with snow around, correct?
Yes.
There were no police on scene.
No.
There was no tent protecting the front lawn, correct?
Correct.
No crime scene tape stapled anywhere or taped anywhere, correct?
Correct.
Nobody appeared to be standing guard over the front yard, correct?
Correct.
You didn't see any shard of glass, right?
No, I did not.
You didn't see 45 pieces of tail light strewn about the lawn, correct?
Correct.
In fact, you didn't see any pieces of tail light, correct?
I don't recall seeing anything.
And you didn't suspect that 34 Fairview was a crime scene, correct?
Objection.
Sustained.
There was nothing that prevented you from walking all over that front lawn, correct?
Correct.
It was still snowing out?
Yes.
Brian Albert, when you approached the house, he opened the door, correct?
I approached the car, not the house.
Oh, okay. You approached, whose car was it?
My nephew Brian's
Brian?
in the driveway. Yes.
All right. And then Brian Albert opened the door of the house.
The side door of the home. Yes.
All right. So can I have Exhibit 8, please, with the court's permission?
Yes.
Could we zoom in just a little bit? That's good. I am so bad at this stuff. Jeez. Oh, thank you. You're welcome. All right. That I'm highlighting now is the front door to the house, correct?
Yes.
And if we move along Exhibit 8 to the right, is that the side door?
Yes.
And that's the door that Brian Albert appeared from?
Yes.
And you were able to see him from the outside of the house, correct?
Yes.
And you were over to this area?
Yes.
Do you recall, is it one of those two cars that's in Exhibit 8 that you approached with the Dunkin' Donuts?
I can't make out what the cars are.
Okay. But it was either one of those two cars or a car that was parked in one of those two places.
Yes.
All right. And then did you go in that side door to go into the house?
Yes.
Fair to say that family has lived there for quite a while, correct?
Yes.
You knew that prior to Brian Albert and Nicole, I'm sorry. Oh, I'm sorry. That's really bad form to block the jury. I am so sorry. It's good I didn't trip. The door that is the front door, having been familiar with that house for a long time. You've gone in that front door before, correct?
Yes,
And you know that when you go in the front door of that house, you come into a little foyer area, correct?
correct.
And then almost within arm's distance to the left is the door to the basement, correct?
Walking in the front door, arm's distance to the left.
Yes, in other words, you walk into the house.
Yep,
And then the door to the basement, going down to the basement is right there on the left, correct?
that's incorrect. To the left is a library.
All right. Where is the door to the basement?
You walk in the front door, you step to the right, walk a few steps towards the kitchen, and the basement door is on the left before you enter the kitchen.
All right, but the kitchen's off to the left, correct?
No, when you walk in the front door, the library is on the left. There's another room on the left.
Okay,
So you walk in, you immediately see a staircase in front of you,
yeah,
and to the left is the library.
right.
If you go to the right,
I'm sorry, go ahead.
if you go to the right, you can go into the part of the kitchen where the kitchen table is, or you can not go to the right, you can walk straight, and as you're walking, there's a door on the left, and that's where the basement door is.
Okay, so I think we're getting to what I was getting at. If you walk straight ahead, there's a door to the left that goes down to the basement, correct?
Correct. Yes.
We can have the lights on. And when you were walking toward that side door, you didn't see any emergency or police vehicles outside, correct?
No, I did not.
And you didn't see any first responders other than Brian Albert, correct?
Correct.
There were no lights flashing outside the house, correct?
Correct.
And inside, you saw Nicole Albert,
Yes.
Brian Albert,
Yes.
Jennifer McCabe,
Yes.
Matt McCabe,
Yes.
and Brian Higgins, correct?
Yes.
How long did you spend at the house that morning?
I don't remember exactly, maybe a half hour, 45 minutes. I don't remember exactly.
And the seven of you were discussing what had happened, correct?
Yes.
At some point, it was decided that Jennifer McCabe should contact Michael Lank of the Canton Police, correct?
Objection.
If this witness knows independently.
Can you repeat that once more, please?
At some point, it was decided among the seven of you that Jennifer McCabe should contact Michael Lank of the Canton Police Department.
I don't remember who exactly Jennifer decided. Yeah, I don't remember exactly the discussion.
You knew Michael Lank, correct?
Yes.
And at 8:53 a.m., you sent to Jennifer McCabe Michael Lank's personal cell phone number, correct?
Correct.
And did you then see Jennifer McCabe delete that text message from you?
Objection.
You were contacted
Uh-oh.
by the Massachusetts State Police this year about your phone, correct?
Correct.
They left you a voicemail on March 21st of 2024?
The state police
Yes?
about my telephone?
Well, they left you a voicemail on March 21st of 2024. You've had contact with the state police this year.
Yes.
And they left you a second voicemail on March 25 and then called you again on March 28.
Yes.
You told them that you were sick and you would speak to them on April 1st, correct?
Correct.
And then the state police called you on April 1st, but you did not pick up. Do you recall that?
I do not.
They called you again that same day and you didn't respond, correct?
I don't recall.
But you did learn that they had called your husband on April 1st looking for you, correct?
I don't recall.
All right. After speaking with your husband, you texted the Massachusetts State Police on April 1st, correct?
I think around that. I don't know the exact date.
All right. And you finally,
Yeah, sorry, that objection earlier being sustained. I'm to be honest with you, I missed it. I'm really sorry, guys. It may have been because there have been a number of objections that have also, if you hear a cat, that's Holmes. I don't know why he's calling. He's got plenty of food and water. He's got everything he needs. he's just being very vocal. He's got thoughts. He's got thoughts about the trial. Okay, perhaps speculation. I missed the question, to be honest with you guys. I'm sorry about that. It could be speculation if he's asking for something that she knows or doesn't know, or if it's something that she wouldn't have any reason to know. That would be that's generally speculation.
Finally met with the Massachusetts State Police on April 3rd of 2024, correct?
I would assume, I don't know the exact date, but yes.
And during that meeting, the state police looked through your phone for contact that you would have had with Mike Proctor, correct?
Correct.
Did they seize your phone?
No, they did not.
Did they tell you that they had a search warrant for your phone?
No, they did not.
Did they take it back saying that they had to give it to some experts to do an extraction?
Objection.
Sustained.
They just looked through it after you handed it to them, correct?
Correct.
Then they gave it back.
Yes.
Now, with regard to your contact with Karen on January 28th, it was clear to you that Karen did not appear to be under the influence, correct?
Correct.
You didn't see her stumbling, correct?
Correct.
You didn't see her swaying.
Correct.
She was not unbalanced.
No.
She was not slurring her words.
No.
She was not talking gibberish.
No.
She was engaging in normal conversation.
Yes.
And she held the conversation perfectly fine.
Yes.
She appeared to be under control, correct?
Yes.
She was affectionate with John that night.
Objection.
I didn't come in contact with them like that.
The prosecution needs to stop objecting to things that are just bad for his case. Like, she can answer if Karen Reed appeared to be affectionate with her boyfriend, John O'Keefe, that night. Plenty of witnesses have testified to this. This is something that a lay witness can testify to. So every time he does that, it just flags for, oh, wait, I need to pay attention to this answer. He needs to stop doing that for his own sake.
Well, the two of them certainly were not arguing.
No, not that I saw.
You didn't see any tension between them, correct?
No.
And I mean, given your family's connection to law enforcement, you would not knowingly let someone drive a car if they were under the influence, correct?
Objection.
Sustained.
Everyone appeared to be having a good time that night, correct?
Yes.
And that included John and Karen, from what you could see, correct?
For the 10, 15 minutes I was there, yes.
Okay. Now, after you left the waterfall, it's fair to say that you didn't know precisely where your son Colin was that night, correct?
I knew where he was.
Where was he?
He was at his friend Michael Leonetti's. He left Michael Leonetti's to stop to say happy birthday to my nephew Brian at 34 Fairview Road.
Okay. And you learned that from him, correct?
Yes.
So you had learned that Colin was at 34 Fairview on January 29th of 2022, correct?
January 28th. To Fred.
So is it your testimony that you know that Colin left on Friday night as opposed to after midnight on January 29th?
I don't understand what you're asking.
I don't
What just
understand
occurred
either.
is I asked you whether you knew that your son Colin was at your sister-in-law Nicole's and your brother-in-law Brian Albert's house on January 29th, and you just corrected.
I'm sorry. It was after midnight.
Okay.
So I got confused. I apologize.
Not a problem. So the answer to my question is you learned that he was there on January 29th, correct?
Yes, after midnight.
And you now know that that is the same house outside which John O'Keefe was found dead that morning, correct?
Yes, I do.
And one last question. You were interviewed by Trooper Proctor, and it's fair to say you never told him that Colin was there that night, correct?
I don't recall my interview.
Of course not. Of course you don't. Why would you? You recall everything else.
I have no further questions. Thank you.
All right, Mr. Riley.
Just briefly on.
For sure, a redirect on this one.
Morning, Ms. Allen.
Good morning.
Now, with reference to, you were asking a question about 67 calls over a period from February to September, correct?
Correct.
That's about 7 months, is that right?
Yes.
And roughly about 210 days or so?
Yes.
Do you have other friends besides Ms. Proctor?
Yes.
And versus some of your other friends, as far as those phone calls, 67 times over 210 days, is that more so, less so, or on average with?
Less so.
Less? And at no point in time did you speak to Ms. Proctor that you recall about this case or talk to Mr. Proctor outside of that interview?
Correct.
In the interview that you had with Trooper Proctor, there was another trooper present, correct?
Yes.
And you would just ask some questions about meeting with some other troopers this year in 2024, correct?
Correct.
And fair to say none of those troopers was Trooper Proctor, correct?
Correct.
And also wasn't the trooper that was with Trooper Proctor when you spoke to him.
Correct.
And they asked you questions. You had at least 2 interviews with them, is that correct?
Correct.
And you voluntarily went to those interviews?
Yes.
You answered their questions?
Yes.
They asked for your phone?
Yes. When I was sitting there, they looked at my phone. Yes.
So they asked for your phone, you provided your phone?
Yes.
Voluntarily, nobody threatened you with a search warrant or anything like that?
No.
You were asked some questions about timing, and I promise there's no math that I'm asking in this, but you've had to walk outside when it's cold outside, correct?
Yes.
You tend to walk faster or slower when it's cold outside?
Faster. Me personally.
When you went over to your in-laws' house on the morning of January 29th to drop off donuts for your nephew, you weren't expecting to go inside, correct?
Correct.
You weren't expecting to be standing around talking to people about a friend of yours potentially having died at that point.
No. No.
Nothing further.
May we approach?
Okay. Just feel free to stand up.
All right. So I wonder if they're going to do a recross, perhaps. Let's do some time traveling, shall we? Yeah, if you guys are enjoying the stream, please do like the video. It does help us to reach more people in the YouTube algorithm sphere.
Because we're doing
Okay.
morning recess. You're actually complete. Your testimony was out. It's complete.
Thank you.
All right. So, but let's let the jurors go first because we're doing something that may take a little while. So we got you coffee and bagels. So it'll be a little bit longer break.
I would like some coffee and bagels. Actually, I've already had my coffee for the day.
Just fold your notebooks up, please. Fold your notebooks and leave them on the chair, please.
So I wonder, maybe it'll be Caitlin Albert next. And maybe they're going to go through this photo issue before she testifies. I have a feeling that might be what it is.
You can just follow. You can just follow.
Okay, let's you know what? Let me get questions first before I time travel again. A wolf of chaos. Question: since burden is on the Commonwealth and a not guilty can be determined just by having doubt, would jury nullification not be applicable in this case? So first off, it has to be reasonable doubt, not just any kind of doubt. It has to be reasonable, which I mean, generally speaking, if a juror thinks that that they have doubt about it, like what juror is going to say, I have doubt, but I think it's unreasonable. Generally speaking, folks are going to think anyway, but just to be clear, that is the standard, is it has to be reasonable doubt. If there's any reasonable doubt in the case that Karen Reed murdered John O'Keefe, that's an acquittal. Second, jury nullification. Just to explain what jury nullification is, it's basically when the jury says, yeah, okay, that's the law, but for this other completely different reason, I want to go with this verdict. In other words, to like send a message or like about politics or a social issue or something like that. Like that's jury nullification. It's not supposed to happen. Jury nullification is is something that judges do not want to see, the judicial system does not want to see in general. And so it is something that, if it's proven the jury nullification happened, that's the kind of thing that could result with a new, potentially a new verdict. So it's something that kind of happens sometimes, extremely rarely, but it has, I suppose, happened in the past, where it's just the jury kind of going rogue and doing its own thing and not connecting the the case and the facts to the actual elements involved in the trial. So that's the explanation of that. The Lucian question: how old was Colin at the time of the incident? I think he was 18. I believe he was 18. Folks in the chat can correct me on that if I am wrong. Debbie Faison Cook, Legalbytes, do you feel like the judge would let them say the grounds for the objection? The rulings would be more understandable, or are you following it? Is the jury understanding it? I think, I think that if they were able to state the grounds, folks would be able to follow it much better. But, the jury doesn't need to follow it. They don't need to know the reason for the objection. They just need to know if they are supposed to disregard testimony or not, which realistically, when a jury's told to disregard testimony, do they really? I don't know. That's a bit more like wishy-washy. It's hard to like remove something from your brain when you've heard something. More often than not, it's applicable to the record if and when there is an appeal in the case, assuming that there is one. Flashfan85, Legalbytes, follow up to Debbie Faison Cook's question: why can't they state the grounds for objections? Because in this case, the judge has made that determination going into trial. This was a big discussion ahead of trial. That I know that you watched I'm pretty sure you watched the Hannah Gutierrez retrial with us, where there were a lot of snide bars. Folks were, meaning, if anybody that is new to the channel, if you're not familiar with that term, that is a term that this chat loves to use. It's basically referring to when the attorneys are starting to argue the objection from across the room. And it's sort of a way of sort of grandstanding and motioning to the jury and sort of like, making a case to the jury. It's improper. You shouldn't be doing it. So those are called speaking objections. Generally speaking, what should happen is the attorney says objection. They state the basis for it. Like it's objection, hearsay, objection, leading, objection, speculation, or calls for speculation. So those are, that's generally what's supposed to happen. And then, if they need to argue it, then they say, Your Honor, may we approach? So this, a very good example of that procedure happening the way it's supposed to is during the Depp trial. There was a lot. I mean, you would hear for everything, Your Honor, hearsay, may we approach? It happened a lot. So, and other trials also have had a good job of that. Now, in this case, the judge really wants to protect against snide bars. She took a bit of an extreme approach to it, however, by saying, no, you're not allowed to state the basis for the objection. When they do approach, they are on the transcript. So they're able to make their arguments on the record. Is there anything here, or is everybody leaving? What's happening? Okay. Maybe they also are going to be taking. Yeah, they also are going to be taking a break. Okay. So we're caught up then. So while we're on the break, I'll continue explaining this. So she's taking this extreme approach, basically to oh, here, let me save this. So okay, sorry, back to my train of thought here. So she's taking this extreme approach. It's to prevent snide bars, but really it also has the unfortunate side effect that some of most of the rulings really kind of become a little bit unclear as to what exactly they are objecting to and what it is that she is overruling or sustaining. So it's, I don't love it. I don't love it, but that's the reason why. Larry Huffin, question: am I confused, or is the defense saying John O'Keefe was killed by one of the Alberts and a nephew? Which one? Not Colin, right? I don't know yet. They are definitely suggesting something happening with the Alberts and something happening with Colin. They say someone else killed Karen Reed. Oh, excuse me. Someone else killed John O'Keefe, and it wasn't Karen Reed. That's what I meant to say. So that's what they said in their opening statement. They so far cannot outright point a finger in terms of like making a third party murderer defense, third party culprit defense. They are not allowed to until they have presented sufficient competent evidence, according to the judge's words, that allows them to make that accusation. So that was her ruling before trial in this case on that issue. So what they are trying to do is, I think, to slowly draw out and present evidence about a third party who is responsible for the death of John O'Keefe. We don't know who they think it is, at least those of us who have been, getting most of what we're learning about this case through this trial, I should say. But it definitely has something to do with the folks that were inside 34 Fairview Road. We know that they think that there was a dog involved. We know that they think that there was some kind of a fight that was involved. That's what the jury knows. And that's what folks that have been watching the trial know. I know people that have been following this case for a very long time probably have way more information. Well, undoubtedly have way more information about all of those accusations and what exactly it is that the defense is saying and who they think did it. It seems to suggest that Brian Albert may be responsible there, maybe Colin, but Colin definitely has an important role in whatever the defense says happened. Desiree Morgan, if KR is acquitted, will they continue to investigate other possibilities? See, anytime we ask, will they, won't they? I don't know. I don't know, because it's up to the police to investigate whether it's state or federal is there's jurisdictional issues, but federal investigators are looking into the Canton Police Department, and I guess the Massachusetts State Police. Trooper Proctor Trooper Proctor has an internal investigation that is focused on him, but I don't know if that is. I've heard some people saying that that's related to this case, but I haven't seen anything official saying that it absolutely has to do with this case. It could have something to do with an entirely different case. But yeah, I don't know. It's up to them to decide whether or not they're going to investigate other people. The Lucian, seriously, who put a cop, fire station, whatever, right next to the courthouse? So it actually is pretty common for police stations to be very close to courthouses, and that's because they've got bail hearings, they've got all kinds of things that'll happen. Somebody gets arrested over the weekend for public intoxication and getting in fights or whatever, and then there's a courthouse right there to go in and have to answer for what happened. So it's actually a bit more common. I think that maybe one of the reasons why it's just so noisy is because of, I don't know, this one is just right next to the courthouse as opposed to being like, half a block away or something like that. I don't know. Sandy, Legalbytes, question from El Borate. How is Turtleboy allowed in court? Doesn't he have witness charges? I don't know. I don't know, because I have not been, I've heard allegations about witness intimidation against him. It could be because of the fact that he has like charges against him, but he hasn't been convicted of anything. So I don't know. If he's there, it's because he has a legitimate press pass. So First Amendment is a pretty big argument in a lot of contexts. So I don't know. I haven't been paying enough detail to or paying enough attention to know the details of that particular argument. Shuttered Island, Legalbytes, why don't they ever call him Officer O'Keefe? Probably because there's nothing, well, not to say that there's nothing having to do with him being an officer in this case, but he died, not while working, not while on any kind of official business. That's probably why. Yeah, that would be my presumption. Rebecca Anderson, Legalbytes, when are the expert witnesses coming in, or where in the list are they? So when we look at a witness list for either side, so I've got both of them here. I'll kind of show you guys. Well, this one's got like highlighting and notes on it, but so this is the Commonwealth witness list. This is the defense witness list. And basically it's just a listing of names and where they're from. The Commonwealth has divided it into police officers and civilians, and then I think experts maybe, or is it just police officers and civilians? That's it. Okay. Unless they have a separate list that I did not come across, that's an expert witness list. I think it should be in here. Their experts should be in here. But they just like they indicate like Dr. Justin Rice, Good Samaritan Medical Center, Daisy Ormseth, nurse practitioner, Good Samaritan Medical Center. So they, there are some indications about like where these people come from. There is Terry Kuhn from UC Davis Veterinary Lab. So I anticipate that that's probably going to be an expert on animal wounds, perhaps, as like a battle of the experts here. There's also someone from Bode Technology. So so this should include, this includes their expert witnesses. They're kind of just filtered in for the Commonwealth. The defense, however, the way that they sort of separated their witnesses was they separated them by lay witnesses and then expert witnesses. They designated 6 expert witnesses for the defense. And so we don't know the ordering of these witnesses from the defense or from either witness list. It doesn't tell us what order they're coming in. It doesn't even tell us like guaranteed that they're going to be testifying. All the witness list does is reserves the right for that party to call that person as a witness at some point during trial. They may or may not call all of these people. Looking at the sheer number of people, and sometimes witnesses will be on both lists, by the way, because they just want to make sure that they can get testimony from that person, even if that person is basically has adverse interest to their party. So the Commonwealth has 87 people on their list. Yeah, 87. And the defense has 77, and there is a lot of overlap, because now that I'm kind of looking at it, I've spent more time looking at. Oh yeah, they both have the UC Davis Veterinary Lab witness. They both have them on there, so there's actually a lot of overlap between these two. So I think that once we get to the defense case in chief, it probably will go faster, partly because they just ask. I mean, so far they ask better questions, but also because a lot of these witnesses, there is quite a bit of overlap. I mean, like the defense has Brian Albert, Caitlin Albert, Christopher Albert, Colin Albert, Julie Albert, Kevin Albert, Nicole Albert, the entire Albert family. And then like, the Kolakithises, which we already saw. So there are quite a few of these that overlap. So, they basically are just reserving the right to call those people. It doesn't tell us anything about the order. That was a very long answer to a very simple question. I apologize, but we've got time. So, yeah. Oh wait, let me see here. There was a question here. Oh, it hasn't come in through. Here we go. Notice, did you just say that they have common expert witnesses? Is that normal? Um, well, I don't know. So to be fair, I don't actually know for a fact if that witness is an expert witness. I looked at that and thought, if somebody's from a veterinary lab, they probably are an expert, but it could be that they sent particular like DNA samples or something like that to the veterinary lab for some results to see if there was a like DNA, like dog DNA or something like that. I'm not sure. Yeah, I don't know, but it is. I mean, it's possible. It's possible for both sides to call the same expert witness. But we definitely are going to hear something about dog DNA or something. Let's see. Moving on with the questions here. Jerry Roth. I wouldn't think this Barney Fife Police Department would investigate anything if their patsy is acquitted. Yeah. I mean, considering everything that's gone on here, I have a feeling that at the end of this, it's probably going to be just the end of the road for this whole case, which is unfortunate for the family of John O'Keefe, because to me it does seem like this investigation was done in a very, very poor way, in a way that no victim's family deserves to have happen. There's no justice in that, for sure. Mike Olson, question: what would/could happen if they ignored the judge's wishes and actually said objection, hearsay, or whatever, contempt of court? She probably would give them a very sharp reprimand on that, and I mean, the reprimand would be on a sidebar, and then she would give them the reprimand like on the record, I guess. If they do it a number of times, there could be sanctions. There could be a number of things. Just because suggestion: when prosecution rests, use the clip from Titanic. It's been 87 years, but cut it off before years and say witnesses. Perfect. Life on makeup. Did you hear Julie correct the defense on the date so she can remember that, but not the most basic things? Was this an intentional slip up by the defense? I don't know. Because sometimes they do play play dumb to some facts, just to sort of like get the questions moving and to sort of set up a series of steps to get to another place. Yeah. So yeah. I don't know. It certainly was interesting what she could remember and what she couldn't, and sometimes depending on who was asking. Janet G, do we know if today's a full trial day? From what it appears, today is a full trial day. Now, I did see something on Twitter about a motion that was, I think, granted, that was filed by the prosecution about children witness testimony. And I don't know if that will be this afternoon, because okay, let me back up for a second. Specifically about children witness testimony not being recorded. Anyone in the courtroom that is there not being allowed to broadcast it in any way, not being able to record the audio or to report on like specific identifying details, even though we all know who they are because like other witnesses have testified to their first names. But the televising and audio recording of their testimony, understandable. And this is because it's kid testimony. Anytime we are dealing with children testifying in a court of law, we want them to be able to testify, but we also want to protect them as much as possible. So that's just one of those things that is like basically default. There's no like what was I gonna, like, I don't know. There's no drama around it, basically. All right. Family man Donnie. Legalbytes seems like the FBI will pick up the pieces after the trial. They aren't exactly hiding their involvement based on preliminary hearings. Fair.
Back on the record on the Reed matter.
All right, sort of a side issue in the Reed matter. So the defendant and her lawyers have been excused. Okay, so why don't counsel identify yourselves, please?
Sure. Adam Lally for the Commonwealth, Your Honor.
Okay.
Tara McLaughlin for the Commonwealth.
All right, good morning.
Good morning, Your Honor. Timothy Bradel on behalf of non-party Aidan Carney, who
Oh.
for the record is present in the courtroom.
Hey, does Mr. Carney want to sit with you?
I think he's okay right there.
Okay.
If that's all right, Your Honor.
All right. So
Interesting.
Commonwealth. So I do want to say a question before we begin. Commonwealth, in your motion to exclude an individual charged with witness intimidation in connection with this case from the courtroom during the testimony of certain witnesses, before we begin, are you advancing the concerns of the DA's office or the concerns of the witnesses themselves, or both?
Both, Your Honor.
Okay,
Judge,
so.
if I may, I'm sorry to jump in, but just if I may, I
Sure.
do have what I think is a pretty substantial procedural objection.
Okay.
Maybe I'd ask that you sort of just make a quick bifurcation of the issues here, and we can address the procedural issue before we get into the substance of the motion.
Sure.
Okay,
I'll
so
hear you.
just to be clear, what's going on here? Let's see. There is a question here. Matt Genere. Yeah, I think Genere. That's how you pronounce it, right? Correct me if I'm wrong. What is a non-party? That means this is somebody who has an interest in the current lawsuit, but is not one of the parties in the lawsuit. So it's rare for a third party to have an interest in a criminal case, but it usually has something to do with media. And Turtleboy is, as we were talking about earlier, folks referenced it in the chat. I don't know too many details about it. I'm going to learn some things maybe here during this hearing. But there is an allegation against him, or a criminal charge against him, for witness intimidation. So that question was really probably very well timed earlier in the chat about how is he allowed to be in there, because this hearing may address that particular issue. This is a is it witness intimidation or is it First Amendment free speech? It may have something to do with that issue. So non-party, just to kind of tie it back in, is basically when someone else that is not actually like in the lawsuit, it's not plaintiff or defendant or prosecution or defendant, but they have some other sort of side issue, side interest in the case. They can be called a non-party, but they are, need to be heard by the judge on a particular issue. And that's the reason why this hearing is coming up, because it's related to this case. The whole witness intimidation thing is related to the facts of this case, the witnesses involved in this case. So even though he's not a party, it's related. And so this is, like I said, this is on that particular issue. So let's see what happens.
Good. Thank you very much, Your Honor. Your Honor, so the record is clear.
So sorry, just to clarify also, he referred to him as Aidan Kearney. That's his actual name. Turtleboy is his like YouTube name, his social media name.
Because we may need an appellate record in this case.
Okay.
But I was here in the Norfolk Superior Court today, completely unrelated to Mr. Carney, my client, as you know, in the other matters. And I was here today on the matter of Commonwealth versus Tylee Curry for a motion to suppress. And
Which is a case that I am in the middle of
Right.
that motion to suppress with you.
Exactly. And I actually figured that we wouldn't do the motion and get a date. But I was fully focused on that matter and had no notice whatsoever that the Commonwealth was in the Reed matter, was seeking to exclude my client as a journalist from this courtroom. The first thing is that, and I know the court has a job to do in terms of ruling on this motion, and that's fine. And I ask that the ruling be that it be denied on procedural grounds. The procedural grounds are, Judge, that there's been no service of process whatsoever on a case where the government is seeking to essentially trample all over my client's First Amendment rights as a journalist. On 15 minutes notice. You know, I know you gave me the thing 15 or 20 minutes ago.
And it's more than a half an hour, but I understand.
Yeah, Debbie Faison Cook. This is Turtleboy's lawyer who's representing him, and like I said, this is what I thought it was going to be. It's an issue of witness intimidation versus First Amendment rights, because as a even though he's an independent journalist, he's got First Amendment rights as someone who is involved in journalism.
All right, well, you get
Also, he has separate First Amendment rights as just an individual, but related to this particular issue, it's about media.
the point. So, this is not something.
And also, sorry, I'm gonna go back because I keep interrupting. But the issue specifically is whether or not he's allowed in the courtroom, considering the witness intimidation charges and considering his First Amendment rights as a journalist.
This notice. I know you gave me the thing 15 or 20 minutes ago.
And it's more than a half an hour, but I understand.
All right, well, you get the point. So, this is not something that I can process and absorb and make any sort of cogent arguments on the merits of the motion on that time period. I'm sure that the court respects that. I'm trying to address it as best I can, but I think that the procedural issues here should control. And here's the procedural situation, Your Honor, that the government filed this 6-page motion. There's a footnote 2 that refers to them serving this motion on May 8th to the Associated Press. Why they couldn't just pull up my email and serve me is an open question that I'd like an answer to in open court. So they can serve the AP 2 days ago, but they can wait and not even serve me with the motion when I get here to court today on a completely unrelated matter, I might add.
Ooh,
so
that's an issue.
there's some funny business going on here. There's been nothing but funny business from where I sit from the Commonwealth on Mr. Carney's matters. And here we go again. So
well, I don't know anything about the history, but
I don't appreciate that from counsel from the Norfolk County DA's office, number one. Number two, Your Honor, Mr. Carney has covered this case and written about 350 news articles on this case. He has developed evidentiary scoops on this case that have added to the quantum of evidence in the matter. He's never caused a problem. He wishes to be in the galley of journalists like everyone else and cover the case. There's never been a problem whatsoever. This is more personalized retaliation from the Norfolk County DA's office against Mr. Carney. Another point, Your Honor, is that this matter, as far as the Commonwealth is concerned, is res judicata ×2. Judge Krupp in this very court addressed this exact issue about Mr. Carney covering this matter, being in the courtroom with witnesses that had a stay-away order. All the same people that the government is trying to have another bite at the apple with here. All these people, this was adjudicated fully with the special assistant DA before Judge Krupp, and Judge Krupp ruled against the Commonwealth. Judge Krupp.
So when he said res judicata, so the subtitles got it wrong. It said like race judicata. Oh my God. No, cat. No. Oh my God. Sorry. The cat just, oh geez. The cat just, let me go back a little bit.
Regardless of any of these witnesses in the stay-away order.
Hang on.
2 that refers to them.
Hang on. Sorry.
Thing is,
I'll hear you.
we could. Thank you very much. I was fully judged that there's, this is not something that I can
A little bit further.
And, there's been nothing but funny business. And Commonwealth on Mr. Carney's matters. And here we go again.
Okay.
So he has developed that he wishes to be in the gap.
Okay, I think we might be a little bit ahead of it, but what I was saying is res judicata is the term that he the Latin term that he mentioned, and that basically means this has already been adjudicated. And he kind of mentioned that afterwards. So for context, you guys may already understand, but basically, Kat, please do not step on the keyboard again. But basically, this is it. He's saying that this is an issue that has already been fully litigated between the parties. They've had a full opportunity to be heard one way or another, and that, you know, the judge has already made this determination. What that means is it's like a judicial economy argument, and it's a very strong argument. If in fact that actually has already been determined, then that's a very basic concept in law. Like that's one of the things that like every single bar exam goes over the concept of res judicata. So every baby attorney that is brand new on day one practicing after having just been sworn in knows the concept of res judicata, that like if you know that something has already been determined and, you know, there's no new facts, there's no new anything in the case to warrant revisiting this issue again, then that's something that should be tossed out very quickly. It's a judicial economy kind of argument, and also like a justice kind of argument, that someone who is being, you know, like sued or otherwise targeted by a particular charge or a particular lawsuit shouldn't have to like argue again and again and again for something that they already won on. So that's what that is. Okay, let me go back a little bit more, because I think I'm a little bit ahead of what he said.
To the quantum of evidence, Jerry,
Okay.
50. Mr. Carney has covered this case and written about three
Okay. Oh, sorry.
oops on this case.
350.
He's never caused a problem.
Okay, we might be a little bit behind.
He
where we were,
wishes
but
to
that's-
be in the galley of journalists like everyone else and cover the case. There's never been a problem whatsoever. This is more personalized retaliation from the Norfolk County DA's office against Mr. Carney. Another point, Your Honor, is that this matter, as far as the Commonwealth is concerned, is res judicata ×2.
res
Judge
judicata.
Krupp in this very court addressed this exact issue about Mr. Carney covering this matter, being in the courtroom with witnesses that had a stay-away order. All the same people that the government is trying to have another bite at the apple with here. All these people, this was adjudicated fully with the special assistant DA before Judge Krupp, and Judge Krupp ruled against the Commonwealth. Judge Krupp said that Mr. Carney was able to be in the courthouse covering this case regardless of any of these witnesses in the stay-away order. The stay-away order was exempted from Mr. Carney's presence in the courtroom, rather, was accepted from the stay-away order.
Okay.
So this is done. This has been adjudicated. It's been adjudicated again, Your Honor, by Judge Pomeroy across the street in the district court. One of these people associated with Mr. Carney's detractors, Ms. Gattani, has taken up with the Commonwealth and sought charges and sought a restraining order against my client. And Judge Pomeroy recently, as recently, I think it was a couple of weeks ago, we were across the street, Your Honor, seeking to vacate the order under the doctrine of unclean hands because this plaintiff keeps trying to contact my client while under a restraining order. Putting that aside, the ruling in that matter, Judge, was another ruling in support of Mr. Carney's First Amendment rights. It was another ruling that said Mr. Carney was not subject to the restraining order in any court of the Commonwealth. And the reason we brought that motion, Your Honor, was because these same witnesses that the government here is, again, trying to advocate for their own personal issues, those same witnesses somehow took up with this plaintiff across the street, Ms. Gattani, brought her to court here in prior Reed proceedings to kick out Mr. Carney, because at the time she had an operative order against him. And Mr. Carney, to his credit, got up and left and got out of here. And that situation was what we addressed across the street with Judge Pomeroy. He agreed with us and said, you can go to court, you can cover this case. So number two, litigation number two, this has been established. Mr. Carney followed all proper channels. We worked with the SJC media office. He has a press pass. He's doing everything in accordance with all of the rules and regulations that are in place. He's been harassed, and we have it on video, by other so-called journalists on this case at the steps of the courthouse. And he just wants to be here. He doesn't want to be an issue in this case. He wants to sit here and cover the case. He's done his job. He wants to watch the trial unfold. And he has an absolute fundamental First Amendment right to do so within the confines of this courtroom and within the confines of time, place, and manner restrictions. He's followed everything, and he's here. We've gone through all of these hurdles, Your Honor, and Mr. Carney triumphed, as he should, because it's the First Amendment that needs to triumph here, not any particular person. And that's what he's doing. And there's absolutely no reason for the government to sneak behind my back to interfere with his First Amendment rights. It's outrageous. And on procedural grounds, I ask you to deny the motion for all of those reasons. And if the court has some hesitancy to do so with respect to these procedural issues, I ask that you set a date give me 7 days or so that I can properly respond to this motion on the merits of whatever's in these 6 pages of the motion that I haven't been able to look at. So thank you for hearing me, Your Honor.
All right, sure. And you wanted a response to your question from Mr. Lally on why you were not served, but the Associated Press was served.
That's correct.
So if you
That's
talk about
Turtleboy,
that,
if you guys aren't
procedural part of
familiar.
this, Mr. Lally?
Yes, Your
The
Honor.
white or
Simply
gray
put,
jacket.
Mr. Bradel, neither Mr. Bradel nor Mr. Kearney are parties to the case. I can't presume that Mr. Bradel's representation on one criminal case is going to extend to a motion of which he would be at best a third party on a separate criminal case. We are required under the SJC rules to serve it upon the Associated Press, which we did.
So I think that's your record now, Mr. Bradel?
Thank you.
Okay, on the procedural issue, okay? We have a jury out. I do want to address the merits of this as best we can. And Mr. Bradel, at the end of this hearing, whatever I end up doing, if you want to come back and readdress it when there's more time, depending on how I rule, I'll give you the opportunity to do so. But I have to get this trial moving at this point, one way or the other. So I'm going to hear the Commonwealth on their motion. Then I'll hear you, Mr. Bradel, to the extent that you can respond, okay? All right, Mr. Lally, I'll hear you on your motion.
Your Honor, very shortly, very simply put, this is an instance in which the Commonwealth is not asking that Mr. Kearney not be allowed to cover the case or that he not be allowed to watch the trial. What we're requesting is a partial closure of one individual. And the legal standard for that is essentially a substantial reason. Substantial reason, Your Honor, being that Mr. Kearney has been indicted and has open cases for intimidating witnesses, specifically witnesses in this case. He has confirmed statements indicating publicly that his actions that he's taken in regard to those indictments were to prevent the case from ever going to trial and to intimidate those witnesses. Those witnesses will be called to testify in this case, and what the Commonwealth is simply requesting is that he be excluded physically from the courtroom, not excluded from watching the trial, not excluded from covering the trial, but excluded physically from the courtroom while those witnesses are testifying from the stand.
And the witnesses you told me have expressed concern. What do you say about that?
Yes, Your Honor. The witnesses have expressed concern. The Commonwealth is concerned as to his presence affecting their testimony or their ability to recall. And for all of those reasons, the Commonwealth would submit the administration of justice and the witnesses being able to testify, as well as the witnesses' own concerns are more than meet the test of the substantial reason for Mr. Kearney's exclusion during the course of their testimony.
Okay. Mr. Bradel?
Your Honor, the witness's concern has no legal materiality under the law. So the answer that I have is, so what? The witness's concern, where does that fit into the law here, Your Honor? This matter's been adjudicated twice. Mr. Kearney has the right to speak on the case. He's gone through all the proper channels to be here. He is not in any way wants to or is trying to make any issue of his presence here. And he's just trying to cover the case as best he can. And this is just a personal vendetta that's been carried out by the Norfolk County DA's office against Mr. Carney. And, you know, this is where the court needs to hold the line on the First Amendment. You know, this witness intimidation statute, Your Honor, is an absolute abomination. It is going to be struck down. It's just a matter of time. And this is just a continuation of everything the special counsel's been doing to Mr. Carney. Now the office itself is doing it. There's no reason for this motion to be allowed, Your Honor. There's no discomfort exception to the First Amendment, Your Honor. There's been absolutely nothing advanced, especially on an emergency basis, which is, I assume, why this is being done with no notice. There's been no establishment of any emergency. There's been no conduct whatsoever on the part of Mr. Carney to justify this motion. And I did happen to see some reference to the Chestnut trial about published, it's something to the effect of doxing a seated juror. That is false. Mr. Carney wrote a story on a juror after the jury was discharged. There's absolutely no prohibition or problem or issue with that. And it is absolutely protected conduct by the First Amendment. And it is not in any way a grounds for this court or the Commonwealth to assert any wrongdoing against him.
So I can assure you I am not considering that incident in this. You all know I was the judge. I am not considering that experience in this motion.
Thank you, Your Honor.
Anything further, Mr.
Nothing
Bradle?
further. Thank you.
All right. So, Mr. Bradle, I agree with you that Mr. Kearney is certified by the Office of Public Information pursuant to SJC Rule 119, and that he has a right to be here today. He arrived timely, and that he is registered. I have honored that 119 registration today, and I will continue to honor that. However, my role in this case, Commonwealth versus Karen Reed, is to assure that the defendant's constitutional right to a fair trial are honored and upheld. And because of the chilling effect that Mr. Kearney's presence, I find, will have on the witness's testimony, I'm going to excuse him while the named witnesses in the Commonwealth's motion, Julie Nagel, Christopher Albert, Colin Albert, Michael Proctor, Jennifer McCabe, Matthew McCabe, Brian Albert, and Yuri Buchanan. And the Commonwealth also today requested Nicole Albert because of the incidents that reportedly have been held at her home. I'm going to excuse him during all of that testimony. Now, in my media order, if you have it, I'm sure your client has it because they're handed out to the press. Under number 1, I say that anyone leaving the courtroom to the media during the trial proceedings may lose their seat and may not be permitted re-entry unless there is available seating. That will not happen to Mr. Kearney. I will not take away his seat today. For other witnesses who are not subject to this order, that seat will remain empty. No other person of the media will be able to take that seat in his absence. Okay?
Your Honor, one last thing, if I may, just came to me as I was standing here. Extension in same regard as to Nicole Albert for the address would be Brian Albert Jr., son of Brian and Nicole Albert, lives
All
in the
right.
same address.
It's for the same reason. So Brian Albert Jr. All right. So those are my findings, Mr. Bradle. It should give you enough to seek appellate action if you wish. Okay? All right. Thank you for being here. All right. All right. So I'll take a short recess. We can bring counsel back in and Ms. Reed back in, and we'll proceed with the
Let me
trial.
explain a little bit here.
Court, all rise.
All rise for a recess. Okay, so basically, here's what happened. The argument was this is First Amendment versus this witness intimidation statute. So the First Amendment is always going to be a very strong argument. Like if you are a gambling person, gambling man, gambling woman, gambling whatever, you are likely to win on a First Amendment argument, a valid First Amendment argument, because it's just one of those. It's a trump card in a lot of contexts. However, the First Amendment is not an automatic win. There are limitations to the First Amendment, and witness intimidation is also a very important thing. Yeah, let's get rid of that fan. We're not fans of the fan. That's better. Let's bigger indie cam, right? While we're waiting on this recess. So the First Amendment is not unlimited. There are limitations to the First Amendment. There are time, place, and manner restrictions. That's why the judge was able to move the protesters back 200 feet, because she's saying, the substance of what people are protesting or gathering for, or what have you, doesn't matter. It's just, we want to make sure that they are far enough away that they are not disturbing the jurors. They're not, the jurors don't feel intimidated by these crowds and everything else. So that's an example. Like time, place, manner restrictions generally are upheld. And so what this judge has to contend with is a First Amendment argument, basically saying, well, this other statute that is in place for witness intimidation, this witness intimidation statute that they have in Massachusetts, will get struck down by someone at some point. That is not a very strong argument, because that law at this moment, when she's making this ruling, is in fact in place. Now, if he wants to appeal that, he can, and that's one of the reasons why she came to a quick determination. And she mentioned, she's like, so if you want to appeal, you can do that now. So he can continue to make that First Amendment argument all the way up to the Massachusetts Supreme Court, all the way up to the United States Supreme Court, actually, because it's a First Amendment argument, and sometimes those will go, fairly often those will go up to the Supreme Court, the U.S. Supreme Court. But if he keeps losing at each stage, he might go that far, perhaps, assuming that they decide to take it on because they've got a big, a big docket anyway. But so he can continue to make this argument that this statute that's in place is unconstitutional, and therefore it should be, it should be overturned by the courts. So, but that's not really something that this judge really has that much of sway over. And it almost, if you're looking to get this law overturned by the courts, it actually kind of helps you more if the lower court goes against you, because then you get to go up to appeal, and then you get to go up to appeal, and then you're making appellate law at those levels. So that's, anyway, so those are the arguments. And what she said is, look, under the law that is in place, which is this witness intimidation statute, I am going to, say that while these particular witnesses are testifying, the ones she is, narrowly drawing it to particular witnesses. She's not saying he's not allowed to cover the trial. She's not saying he's not allowed to be in the courtroom, full stop. She's saying, while these particular witnesses are here and they are testifying, we have a very, very important job to make sure that witnesses are testifying to their full capacity, and and that they're not being restricted like unfairly. You know what I mean? Like if you take this from another perspective, I have no idea what the actual facts and circumstances are about those witness intimidation charges. I don't know any of the details. But, if we take it to like a hypothetical situation, and I'm not saying that this has happened in this case because I have no idea, but if there is a case where, somewhere, like, let's just, for the hypothetical, let's say that there's gang involvement, right? That there's a gang member that is a defendant for, some kind of a violent crime, and there's a witness who saw it. And there are some kind of like fellow members of that gang that decide to threaten that witness out of testifying. And then they go and show up in the courtroom. That could cause that witness to change their testimony because they're terrified of walking out of the courtroom and then being assaulted or worse. So the court really wants to prevent that from happening. They don't want improper threats or anything like that to be on a witness's mind when they are testifying, because they want them to testify truthfully. They don't want them to change their testimony simply because they are afraid. So that's where that comes from. And that's, courts take that very seriously. Hey buddy, what are you doing? Are you are you looking for stimulation from the other fur buddies? Because Mavi's over here sleeping, Indy's sleeping, and Holmes is just hanging out. Anyway, so I agree with her ruling on that one. I don't know if about the constitutionality of that law, but the courts have a very strong interest in maintaining the prevention of witness intimidation and preventing witnesses from changing their testimony because of, improper reasons, because they feel threatened, because they feel afraid, things like that. Okay. Alrighty. So that's my explanation of the hearing there. Also, oh my gosh, I missed this earlier. Austin, thank you so much for the super chat. You need to start playing the objection from Liar Liar, where the reason Jim Carrey gives is because it's devastating to my case. I might actually need to upload that as a mini clip, just to respond to these dumber objections that are not helping anyone. Pesky pirouette question. Alita, can a witness have their own attorney? Do you ever handhold, act as a guardian angel, or someone called as a witness? I would be terrified. People would definitely pay you to be there. Absolutely. Witnesses have attorneys all the time. In fact, in this particular case, I know that at least a handful of these witnesses have their own lawyers. The ones that were named on that list, the exclusion list, right? The people that are excluding Turtleboy from the courtroom. They all have. I'm pretty sure they all have attorneys. In this case, I know that there are some that have shown up to particular pretrial hearings, I think having to do with the defense's requests to get their cell phone data and things like that. So absolutely 100%. And in fact, like I would recommend it. I would recommend, if someone is going to be testifying in a trial, it's worthwhile to get some counsel beforehand to make sure that you don't, you testify truthfully, of course, always. You don't want to hire an attorney to coach you on what to say, but to guide you through the process, absolutely, 100%. Divine Inhale with Donna Clifford. Question, most important question, what are your prego cravings? They have they've changed over time. In the beginning, I was definitely
You are unmuted.
Ooh. Okay, we've got some activity here. In the beginning, it was all salty things. I needed olives, jarred olives all the time. Nothing sweet really. I've started to lean towards sweets a little bit later on in pregnancy, but a lot of dairy, a lot of yogurt, a lot of high calcium stuff. Let me finish getting these questions and then we'll continue on. Let's see. Am I saying this correctly? Is it Echabelin Euxikaya? I think. Why didn't the attorneys ask the Alberts about the dog when they testified? Wouldn't you be able to ask any pets in your brother-in-law's house? How did it behave when you visited, etc.? Well, maybe because, so with cross-examination, it's best if you have other information like receipts that you can nail them on, because you have to assume that the witness is going to be testifying in a way that's against your interest, right? For example, with the timing of how long it takes to walk from Waterfall Bar and Grill to their home on Maple Street. It might be 7 minutes, but those witnesses have every interest in maybe saying, well, 5 minutes is more likely, because we're interested in being closer to the timestamp that we initially gave on direct examination. So So you have to assume that witnesses are going to do that kind of thing whenever they can, if they have a particular interest. And in a case like this, where they are a member of the Albert family, they are going to have an interest, right? They have an interest regardless of whether or not there is some kind of conspiracy to frame Karen Read. This is the Albert family is also under the gun here in this trial because the defense has made these accusations against them. So there is a lot of pressure on all of these witnesses who are connected to the Albert family and part of the Albert family. So, questions about pets and things like that, when you are asking a question on cross-examination, there's basically two rules. Number one, either know the answer before you ask it and have something to back it up if they stray from it that you can impeach them on. Or number two, don't care about the answer. So this is when the cross-examining attorney asks the question knowing that it's going to draw an objection. And they ask it anyway because it doesn't matter. The power is in the question because the question puts a particular thought in the jury's mind. So those are basically the rules. So with the dog issue, the brother and the sister-in-law may not be able to really answer all that much about the dog issue. And it probably would be a more laser-focused kind of cross-examination if they first address it with Brian Albert and Nicole Albert, the ones that actually owned the dog. That probably would be more effective. And so they just because you can ask someone a question or a series of questions doesn't necessarily mean that you should, because it may not be the best person to get it through. Because otherwise, when the jury starts to hear, okay, I've heard these kind of questions before, I kind of got these sort of answers, I'm probably going to get these kind of answers again, you start to lull them into a non-attentional kind of state. And that's something that the prosecution has been doing quite a bit of. They've been repeating a lot of their questions, and especially a lot of questions details that we don't really care about. We don't really care who was drinking Bud Light or Miller Lite or who was, ordering fries at Waterfall. Like we really don't care about those things. There's a lot that could have been skipped through. And when you repeat these lines of questions over time, you want to make sure that you're repeating them for a good reason. And you want to make sure that you're getting it through the right people. Okay. Ashley Roman, do you feel the judge is pro-prosecution? Just tuning in to your coverage for the first time today. Well, welcome, first of all. I'm very happy to have you here. And, there have been some things that have kind of irked me a little bit. I will be honest. I think that, especially early on, she had a lot of sighing that she would audibly do into the mic when the defense was cross-examining. It wouldn't happen when the prosecution was doing their direct examination. I noticed things like that. And that to me was kind of an issue because it can subtly signal to the jury that the judge has a particular bent. And I don't like that. And sometimes judges do these things and they don't even realize it. But I think that after the weekend, I noticed that she's done it less. I don't actually know that I've really noticed her doing it at all in the last few days. So either she took notice or someone may have kind of tapped her on the shoulder and said, "You're doing this thing. You might want to stop because it looks a certain kind of way." So there have been things like that, but I think that she's gotten a bit better on things like that. And, her objections, she sustains, she overrules on both sides. So overall, like maybe she's got a particular, bias on that she has herself. Judges often will have a close relationship with prosecutors. However, someone pointed out in the chat recently that she actually used to be a public defender, which they go up against the prosecution. So, and like the history of, public defenders, prosecutors, private defense attorneys, oftentimes there are people that shift, back and forth. For example, the defense attorneys in this case, they both are former prosecutors. So, you'll have people that switch sides throughout their career. This judge does have a history of being a public defender. So she does understand what it's like to be a defense attorney and what it is to defend a criminal case. Plenty of experience, I would imagine. I don't know how long she was, but that was her history. And I will say that's relatively rare. it's more common, at least from what I understand from, when I have talked to or observed judges taking positions, that it's more often that they are former DAs or assistant DAs. Not to say that automatically means that they have a bias, because, there are plenty of attorneys that have been former prosecutors, former defense attorneys, or current defense attorneys that will side one way or another on a particular case. Case in point, within LawTube, we've got Emily D. Baker, former prosecutor. She sometimes is pro-defense, or plenty of times is pro-defense on a lot of these cases. There are folks like Ian Runkle, defense attorney. Sometimes he's pro-prosecution. Hannah Gutierrez Reed, he was like so pro-prosecution on that case. Then there's Nate the lawyer, also former prosecutor, and he's gone both ways on cases too. So there are plenty of examples of people having had a history working in a particular environment and not necessarily carrying that with them throughout their entire career as a bias. Long response. Pesky Pirouette, thank you so much for the generous super chat. Love your style, Lita. Money to help with Indian Kitty Street Fund. Thank you so much. I really appreciate that. Okay. So I hope that answers your question, Ashley. But there have been some little annoyances here and there, but overall, I don't know that I've seen enough to really be willing to step forward and be like, yes, she's totally pro prosecution in this case. She's definitely against the defense. Some annoyances here and there, but she might not even be aware of it. I don't know. Tequila Shots 6969, is that the jury? I always thought the jury were kept off camera and anonymous. So I think folks in the chat may have already answered this, but that actually was a mixture of family of John O'Keefe and journalists in the back. So jury is actually behind the cameras. Nico Kiski, question, could you explain the phrase he used earlier, a bite from the apple? I've heard it before, but it wasn't explained and I couldn't understand the explanations I found. So he actually referred to it as a second bite at the apple. A bite at the apple refers to an opportunity or a chance. When somebody uses the phrase, and I know we've got a lot of folks that are not Americans. So this is great. I'm so happy that you asked this, because this is a very American phrase. When somebody says that somebody has a second bite at the apple, it means that they have like a second chance that they're unfairly getting. They're not supposed to have a second chance. So that was in relation to the whole res judicata argument, saying, look, this has already been argued before. It's already been, fully fleshed out, and the judge has made a determination on this. That is dependent on whether or not there's new facts involved, however. And so it seems in this case that there probably are some new facts involved that weren't involved in that previous argument about a similar sort of issue. But basically it means that somebody's getting an unfair chance that they're not supposed to get to argue something. You'll see it fairly often in legal opinions and things like that. Like somebody's trying to get a second bite at the apple. It means that they're trying to claim an unfair second chance when they're done. That's it. They're up a certain creek without a paddle, and they're not allowed to have another argument on this. All right, Pesky Pirouette question. Thank you, Alita. Thank you for that answer about a personal attorney if testifying. If I had to rely on someone like Lily to prepare me, just commit me to the insane asylum now. Understandable, absolutely understandable. And that's that's also another another lesson. It's great to talk to someone. If someone is going to testify, it's a great idea to talk to someone to counsel you that maybe isn't the attorney that's involved in the case, because especially if it's a really big case, they've got a lot of witnesses that they're talking to and a lot of pieces of evidence that they're having to marshal along the way. They might be spread a little bit thin in the whole pretrial process and maybe not able to dedicate the time and energy to properly kind of guide you on like what to expect and what's going to come up and what the other side might be talking about, which if you get your own sort of independent counsel, they may not have the facts on all of that to really be able to like guide you fully, because like to anticipate what's the other side going to ask, for example, but they might be able to sort of issue spot some things here and there. And also otherwise give you some overall guidance on like, this is what happens here. This is what happens here. This is what to expect. Don't take it personally, like that kind of thing. Mr. W, Legalbytes, after 9 days, what's the odds the jury is losing focus at this point? It seems like a lot of repetition to sift through. I agree. I do think that there has been a lot of repetition for sure. And the thing is, it's like, if you guys saw my recap where I talked about the dash cam footage, the driving dash cam footage with Lieutenant Charles Ray at the end of one of the days, where they showed the dash cam footage of him driving up to do the wellness check on the niece and nephew. And then the footage ended with, a rear view of Karen Reed's car, and there's the taillight and that kind of thing. That was a detail that I personally missed initially because of the fact that I was sort of lulled into complacency, because I was like, all right, we've seen so much driving testimony, like, or driving dash cam footage, like none of it has mattered up to this point. But when it does matter, you might miss it. So that kind of thing absolutely can happen. And it wouldn't surprise me if it did with this jury, that they might be just completely skipping over important pieces that the prosecution is throwing out there, because it's just too much information and too much repeated information. All right, let's continue on, shall we?
All right, jurors, once again, thank you very much for your patience. Your next witness, Mr. Lally?
Yes, Your Honor. The Commonwealth will call Ms. Nicole Albert to the stand.
So sorry, he said Nicole Albert, yeah? Yeah, okay, thank you. And also, if you guys are enjoying the stream and you haven't done so already, please do like the stream. It does help us to get more visibility on it with all the YouTube algorithm thingy-mabobs.
Can you raise your right hand, please? You solemnly swear the evidence you give the court and jury in the case now hearing should be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. I just need you to speak nice and loud into that microphone.
Okay.
Thank you.
Yep. All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Could you please state your name and spell your last name?
My name's Nicole Albert, Albert.
And where do you live?
Nord.
And about how long have you lived in Norwood?
About a year.
And prior to moving to Norwood, where did you live? Where did you live prior?
Canton.
How long had you lived in Canton?
My whole life.
Now, the specific address, where did you live in Canton prior to your move to Norwood?
34 Fairview Road.
So for those that are more on the defense, it might seem even more suspicious. I know there's a whole thing about the selling of the house that people on the Karen Reed side find very, very suspicious, and those that are more on the prosecution side are think that that's a bunch of conspiracy. I'm unconvinced one way or another at this point. But the fact that she had lived in Canton her whole life before that point, and then they're like, well, we just wanted to downsize. I'm sure folks that are on the Karen Reed side are probably going to look at that and say, like, I'm sorry, what? And Joshua Marshall, no, I did not just call anyone morons. I not at all, not for a second. Folks, as our good friend Rick Hogue over at Hogue Law would say, reasonable minds can differ, especially on this case, especially. We are working our way through it and trying to make sense of all the senseless data that is sort of amassed here in this case. And, we're all working our way through it and trying to get to the truth with the capital T. So regardless of any kind of, regardless of what your perspective is and how you think about guilty or not guilty in this particular case, zero morons, no shade whatsoever on anyone on, to either side. All right.
And how long did you live at that house?
About 12 years.
And are you married, ma'am?
Yes.
What's your husband's?
Brian Albert.
Does he work?
He's retired from the Boston Police.
About how long was he an officer with Boston?
About 30 years.
And do you have children?
Yes, we have 5.
And how old are your 5 children?
My oldest daughter is 28, and then I have a son who's 25. I have another son who's actually 23 today. And then I have twins, a boy and a girl, who are 20.
And your oldest daughter, what's her name?
Caitlin,
Your oldest son, what is his name?
Brian Jr.
And Brian Jr., does he live with you currently? Now, your other children, do they live with you as well?
My oldest daughter lives with her boyfriend in Easton, and my son Brendan lives with us. He's just finishing up college, so he's graduating this month from college, so he's back with us. My twin daughter, goes to college, so she's home now for the summer, but she has an apartment in Bridgewater. And then the twin boy is in the military,
And which branches?
the Marine Corps.
Now, if I could turn your attention to January 28th, 2022. Do you recall that day?
Mm-hmm.
And do you recall what day of the week that was?
It's a Friday.
And at the time of January 28th, 2022, did you work?
Yes, I've been a part-time lunch lady for about 9 years.
And you've since retired, is that correct?
I'm sorry?
You've since retired from that?
I haven't retired. I just didn't go back this past year, but
And around that date of, so January 28th, 2022, what, if any, significance was the next day of January 29th?
January 29th was my son Brian Jr.'s 23rd birthday.
And over the course of that week, sort of leading up into the weekend, what, if any, plans did you make with reference to your son and his birthday?
He had mentioned he was going to get together with some friends on the Saturday night, the 29th, for his birthday. And I had said, okay, well, maybe Friday night, if anyone's around, any of our aunts or uncles or anyone, maybe we'll take you out, just local for some apps and drinks or something.
And coming up to that day of Friday the 28th, what if anything sort of changed in reference to those plans?
Well, they were, the forecast was saying a big snowstorm was coming in, and it looked like it was going to be late Friday into all day Saturday. So I had said to my son, well, obviously doesn't seem like anyone will be able to go out on Saturday night. Why don't you just do something with your friends Friday night?
And had you, at that time, already made some plans with friends and relatives in regards to going out Friday?
Yeah, I had just mentioned to my daughter Caitlin and my sister-in-law Julie, and just had mentioned it to them about possibly getting together Friday.
And just to be clear for the record, when you say your sister-in-law Julie, how is she sort of related to you?
She's my husband's brother, Chris's wife.
And your husband has a number of siblings, correct?
Yes, he's the oldest of 7.
And yourself and Julie Albert, you guys are friends?
Yes, we're very close.
And so, also just one last question, sort of leading up through the course of that week, where did your husband Brian go?
Sort of last minute, I believe it was Thursday of that week, he went to New York for a funeral.
And you know who the funeral was in regard to?
It was for a New York police officer who had just been killed in the line of duty.
And do you recall how he got there as far as how he went from Canton
I
to New York?
believe he may have flown Thursday to New York.
This is, obviously very sad to be going to a funeral for a fellow, police officer that was killed in the line of duty. I'm not commenting on anything related to that. Absolute full respect for all of that happening. The question is, why are we talking about it in this trial? Other than to create a certain impression to the jury, similar to, Christopher Albert talking about his son being in the Navy, Julie Albert, also talking about their son being in the Navy. Now Nicole talking about their son being in the Marines. That is intended to create a certain impression with the jury. Sort of it tends to get brownie points. We're not in the Vietnam War era where that was a bad thing. We're still very much in a time period where military service is looked upon very admirably. But this has kind of a similar vibe, and I would have been like fine with it if it was one question and then you move on. But now getting into detail about how did he get there, what we don't need to know this information. This is what I'm talking about with the extra fluff of getting into these sort of side quests that Lally loves the side quests. We really need to just kind of get to it.
And then the plan was to fly back Saturday, but that changed with the weather, and they didn't want to get stuck there. So after the funeral Friday morning, they drove home. A friend of his had driven, so he got a ride back with them on Friday.
And only if you know, but as far as that friend that he drove back with on Friday, do you know who that was?
The friend who I believe had the truck there and drove was Brian Higgins.
And is that someone, Mr. Higgins, that you were familiar with prior to that date in January?
Yes, he was a friend of my husband's.
Now, on that evening of the 28th, can you explain to the jury sort of how it was that where did you decide to go with your daughter and your sister-in-law?
We just decided to go to Waterfall, a local place, 5-10 minutes down the road from our house. My sister-in-law, Julie, picked me up at my house, maybe 7:30, 7:45. And we went to the Waterfall, and I believe my daughter and her boyfriend, Tristan, were already inside at a table.
And when your sister Julie came to pick you up the house, in addition to yourself and your son Brian Jr., who, with anyone else, were any of his friends there at that
I
time?
believe 2 girlfriends may have already had come, and they were just sitting in the kitchen when I left.
And so you go out to the waterfall. When you get to the waterfall, where within the establishment did you go?
We came in, walked in. I believe to the left there was just some small tables, and I think Caitlin and Tristan were already sitting there. So we sat down at the table, and we ordered food, and just hung out for a little bit. Had food and some drinks.
And as far as drinks were concerned, do you recall sort of what you were drinking that night?
I was probably drinking White Claw.
God bless you. Now, later on in the evening, was there any sort of live entertainment there?
Yes. After we ate, my daughter's boyfriend Tristan left shortly after because he was going to be going out shoveling, working with a plow guy. So he was planned to go home and just sleep, take a nap, because he was going to have to get up like in the middle of the night
We don't need
to
to know about the band. We don't need to
go
know
out
about
and
their
do
set
that.
list.
So he had
songs they
left. So
played.
it was just me, Julie, and Caitlin. And at one point, the waitress had said, "Oh, a band's going to be setting up where you're sitting. Can I move you?" So she just kind of moved us over to like a high top table.
And then after you were moved over to the high top table, who, if anyone else, came in to join you?
Shortly after, I believe my sister Jennifer and her husband Matt came in. I had texted her just saying I was there, if she was interested to come by. I think she said she was somewhere else. Did I want to come there? And I said, well, no, I'm already situated. The band's going to play. I'm just going to stay here. So she said, okay, maybe we'll come there. So maybe 9 as she came in with another couple. I believe they had been at a basketball game, their daughter's basketball game. So she came in with them.
And again, just to be clear, when you say your sister Jen and her husband Matt, what is their last name?
McCabe.
And she's your younger sister, is that correct?
Yes.
Now, as far as after they came in, who, if anyone else, sort of came in and joined you?
Shortly after that, I believe Julie's husband, Chris, came in. He worked up the street at his pizza shop. So I believe shortly after 9:30, he came down, he came in. And then in the meantime, my husband was, getting close to being back to the area from driving back from New York. So I had texted him and said, hey, me and Katie and whoever else are here, if you want to come by. And he was like, oh, I'm kind of tired. It's been a long day. And I just pushed him a little, oh, well, Katie's here. She, just come. She wants to see you. So he's like, all right, maybe I'll pop in. So I believe so it was Jen and Matt and the other couple. And then Chris came in. And then I believe maybe around 10, Brian came in.
And after your husband Brian came in, was there anybody else that came in and joined you?
Shortly after, maybe 10:30, his friend Brian Higgins had come in.
So your husband, Brian, and Brian Higgins came in separately about a half hour apart?
I think so, yes.
And following that, who, if anyone else, came into the establishment and sort of joined your group at the hot top table?
A little bit later, I think approximately 11, John walked in with his girlfriend,
And when you say John, who is John?
John O'Keefe.
And how did you, or did you know John O'Keefe prior to that night?
I didn't know him that well. I think I had only met him once, maybe twice through my sister. Brief interaction. I think when he first walked in, actually, I didn't recognize him. I think I said to someone, "Oh, who's that?" Because they were kind of walking towards our table. And they said, "Oh, it's John O'Keefe." I said, "Oh." So they came in and they just kind of went to the end of the table where like my sister Jennifer and Matt and Chris and Julie were, because they knew them. I had never met Karen and I'd only met John once or twice. So they kind of just went to the other end of the table where Jen and Matt were, who they know, and Chris and Julie, who John had been neighbors with for a couple years. So they were all just kind of at that end talking.
And probably pretty well understood, but just to be
Sorry, I didn't realize I was still muted. That was a little bit of a long answer to that particular question. But really quick, just because, thank you so much for the super chat. Is Lally trying to get a maxi series made on this? Does he get paid by the hour? So he doesn't get paid by the hour. He is, generally speaking, prosecutors are salaried. So they don't get paid by the hour. They just, they're trying to litigate this case in the best way that they can. The defense, however, is almost undoubtedly paid by the hour. Also, just because, thank you so much for gifting 10 Legalbytes memberships. Once again, very kind and generous of you. Thank you so much. I love the fact that folks gift memberships in this community. It's awesome. Purchases made simple. Mike Olson, Reznov Vasilevsky, Janet G, Ramona Kozma, Christina M, Vicky Lane, Phil Kayo, Baz 80s, Frontline 221. Y'all have been gifted memberships by Just Because. So welcome or welcome back to Bite Club. Very happy to have you guys here. Normally on Fridays at 10 a.m. East Coast time, we have a members only live stream where we all kind of catch up and casually chat about law topics and also other stuff. So it's a fun time for the community. So I hope that you guys can join us, although this week, obviously not happening today. So it'll be happening tomorrow at 10 a.m. East Coast time. So thank you so much, Just Because. Very kind of you. All right, back to the testimony.
clear, as far as the sister that you knew of John through, that was your sister that was there, Jennifer?
Yes, Jennifer.
And as far as you referenced his girlfriend, had you ever met his girlfriend before that night?
No.
Had you ever, so you had never met Karen Reed prior to that night, as
No.
far as you recall?
Nope.
And at any point in time, did you have any interaction, or what, if any, interaction did you have with either Mr. O'Keefe or Mr. Reed?
At one point, John walked by, towards me and my daughter at the table and said, "Hey, I'm going up to the bar. Do you guys need a drink or anything?" And we said, "No, thank you." I think he then kind of stopped and spoke with my husband for a minute, probably was asking him the same thing. Then John went back up to the bar, and then he went back down to, where he'd been standing. And that was the only interaction I had with him.
And as far as your understanding or your knowledge of Mr. O'Keefe, did you know what he did for a living?
Yes.
And what did he do?
I knew he was a Boston policeman.
And was he somebody, if you know, that worked with your husband?
No, I don't believe he ever worked with my husband. I don't believe they ever crossed paths at work. I think they were in different areas of, the job.
Fair to say the Boston Police Department is a relatively large department, correct?
Yeah, it's like 3,000.
Now, with reference to Ms. Reed, what, if any, interaction did you have with her that night?
I had none. I don't believe we spoke or we were introduced or anything. I don't think we spoke at all.
Now, turning back to Mr. O'Keefe just for a second, if you recall, what, if anything, do you recall him to be wearing as far as clothing was concerned during your interaction?
I believe he had a hat on, some sort of just sweatshirt, jeans, and sneakers.
At any point in time that you saw him or while he was talking to you, did you see any sort of like winter jacket or big coat or anything like that?
No,
And as far as his clothing was concerned, did you observe it to have any sort of tears in it or any dishevelment, anything like that?
no,
And as far as his face was concerned, or any sort of outward part of his body, did you observe, or what, if anything, did you observe with regard to injuries on him or anything like that?
nothing like that.
Now, as far as your home was concerned, was that somewhere that either Mr. O'Keefe or Ms. Reed had ever been to before?
No,
And over the course of the evening, what, if any, discussion was there that you heard or were a part of in regard to sort of what was going to do or where to go after leaving the waterfall?
well, after the band wrapped up, I was getting ready to leave, and I just kind of leaned over to my sister Jennifer and said, "Hey, you know, Brian Jr.'s at the house. I think he just has 2 friends there. He's going to be turning 23 at midnight. If on your way home you wanted to swing by and say happy birthday, you know, if you want to do that, come by and do that." And she was like, "Okay, you know." And then I was just kind of gathering up my stuff, and I got ready to leave. It may have been mentioned at the table, but I had no idea, you know, if anyone else was interested in doing that or wanted to do it. I had just said it to my sister.
And if anybody else had wanted to join or come along, would that have been an issue?
Oh, no, I would have no problem if anyone sitting with us had come.
But as far as you knew, you just communicated that to your sister Jennifer, and whatever happened after that happened.
Yes.
And when you say sort of the band was wrapping up and the bar sort of winding down, is that correct?
Yes.
About what time was that?
Like 12:45.
And about what time was it, if you know, about what time was it that you left the bar?
A little before 12-ish.
And who, if anyone, left with you?
It was me, my daughter, Caitlin, and my husband.
And how did you get from the waterfall back to your house on this?
My husband drove the 3 of us back to Fairview Road.
And when you came outside of the waterfall and were sort of, you know, getting into your car and about to drive home, what, if anything, did you observe as far as the weather or what was going on at that point?
It was just starting to snow a little, nothing major. Just a little snowfall started coming down.
You could still sort of see the street and the blacktop.
Yeah.
And again, about how long a car ride is that, generally speaking, from the waterfall to your house up there?
5 minutes, 7 minutes.
And as when you arrived at Fairview, who, if anyone, was there when you got there?
When we arrived and I came in, my son was sitting there with his 2 friends and my nephew Colin, who is Julie and Chris's son. He was there. I kind of bumped into him when I walked in. I didn't realize he was there. I said, "Oh, hey, you know, what are you doing here?" And he said, "Oh, I just stopped by to see Brian, but I'm about to leave. My ride's about to be here." I said, "Oh, okay."
And let me back up just for a minute. So when you arrived there, your husband Brian is driving. Where does he park in relation to the house?
We pulled into the driveway.
And typically, is there sort of an order to it as far as where the cars go, like his car versus your car versus any other car?
Not really. No.
Do you recall on that evening which side of the driveway he pulled into, the left?
I believe it was in front of the left garage.
And when you come into and enter into the house when you were living there at 34 Fairview, was there, how many doors are there sort of on the front of the house?
Well, there's a side door by the garage, and then there's like a front door in the front of the house.
And is there any sort of particular rhyme or reason as to which door you would be entering?
We usually use the side door. You know, initially I didn't like that because the side door walked right into the family room. So I kind of liked the other door. You could walk into a foyer you could take your shoes off, stuff like that. But eventually the people just didn't want to, it was, you know, quicker to walk in the side door for the kids, I guess. So they would just go in the side door. But I think that night, because of the weather and it was wet out, I think I went in the front door so I could walk into the foyer and take my shoes off or wipe my feet or whatever. But some of the other people still may have gone in the side door.
And
This is what happens when I have snacks on streams. I always mute myself and I forget to unmute myself. Bleh. That was a whole long thing of me talking and not saying anything. So what I was saying is that I think that so far, my first impression of this, Elaine, oh, please don't puke on my computer. What are you doing? Sorry. Mavi just like randomly gagged. She's like right next to my computer. I thought, oh my God, that scared me for a second. Woo. Okay. So anyway, I'm not still muted. Okay. Yes. So anyway, what I was saying is that my first impression of this witness is that she's coming across sympathetically. You know, I know that she's under a microscope by a lot of people and for a lot of reasons. And I'm not saying any of those reasons are in any way bad. There are many good reasons why folks are paying a lot of attention to her and all of the other Alberts. But for me, for my first impression, I've never seen this witness before. I've never seen her talk before. I've never seen her, testify or give any kind of explanation or present anything. She is coming across sympathetically to me. Of course, we will see how that goes on cross-examination, how that holds up. We have seen plenty of instances on this channel of where a witness testifies on direct examination and then, looks phenomenal on direct examination. And then on cross-examination, things just completely look different because of what gets revealed and how things play out. So anyway, okay, let's get back. I just wanted to give those observations on that. And I'm not going to mute myself again because I'm not going to have any more snacks before the recess.
When you sort of come into that front door where you were going in to sort of take your shoes off in the foyer, is that when you ran into your nephew, Colin?
Yes.
And about how old was Colin around that time?
It was 17.
And you mentioned that he had a ride. Did he give you any indication as to who that ride was?
He didn't mention at that time who the ride was.
And that sort of interaction that you had with Colin in your house prior to him leaving and walking out, about how long a period of time is that?
Couple minutes, not even, just a quick interaction.
And then he left the home. You didn't see him for the rest of the night.
No.
And then you come into the home, and again, I'm sorry, who was there sort of initially when you come?
So my son Brian and his two friends Julie and Sarah were just kind of sitting at a kitchen table in like the dining room area of the kitchen.
If you could explain to the jury sort of the layout of your home at Fairview. So you walk into a foyer, and then where is the kitchen related to that?
Well, if you walk in, if you go to the right, it's like an open doorway, and that's kind of like the dining room part of the kitchen, but then it extends to the back of the house where it's like an island and like the sink and the counters and the cabinets and all that. So it's just like long.
So as far as the dining room and the kitchen, is there any sort of like wall or structure?
No, it's open in between the two of those things.
And then if I were to go sort of further back within that home beyond the kitchen and the dining room, what's back there?
Well, to the right, there's like the family room.
And is there anything as far as a wall? Can you see into the family room?
You can. It's like an opening. Yeah, it's not completely open, but there's an opening.
So if someone was standing in the family room and you were standing in the kitchen, you could see them, converse with them, that kind of thing.
Yes.
And when you come in and your son Brian Jr. is sitting around the table with two girls, Sarah and Julie, what are they doing?
We're just sitting there.
Was there any sort of music playing or anything like that going on?
There may have been. I'm not sure if there was music playing at that time, but there might have been.
When you say at that time, was there anything that happened later on?
Well, later on, I remember that we had music connected to like a little speaker that we were playing.
KBL, like
Yeah.
Look, there could be some circumstances under which, music playing, a band playing is important, right? Because if there's a conversation that happens that is material to whatever the facts or circumstances are in the case, this is not one of them. We got to move on. Like, come on, let's get beyond the band. Let's get beyond the music. Like let's get to the parts that actually matter.
But when I first walked in, I don't remember if they had music going or not.
And you get back to the house, and what is it that you're doing sort of when you come back?
So I come in, I assume I said happy birthday to my son, said hello to his friends, and then I just kind of went to the kitchen area, and like they had ordered food. And so I just did my usual thing. I just was picking up, wasn't a huge mess, but I was just picking up the area, cleaning, probably check the bathroom to make sure that was clean. Just my usual thing that I do, just picking up around the house.
And I don't mean to minimize this in any way, but you basically, you did the mom thing where you go around and start cleaning up, correct?
Yeah. Yep.
And is that something that you did sort of continuously throughout the evening, or?
Yeah, that's kind of what I do.
Now, after you arrived home, who, if anyone else, came by your house?
Well, once we were there, it was me and my daughter and my husband, and Brian Higgins had come in. And then it was, Brian and his two friends were already there. And then my sister Jen and her husband Matt came in maybe like 12:15-ish.
And so, Mr. Higgins, did he come in around the same time as you, or did he come after or before?
Yeah, he came in the same time. I mean, I think he might have pulled up to our house before us. But we got out of the car and went right into the house. So I assume he just came in, basically around the same time.
Do you have any idea sort of what Mr. Higgins was driving that night when he came to your house?
I believe it was a Jeep.
Do you have any idea where, in reference to your house, where Mr. Higgins parked?
I'm not sure. I thought it was out on the curb facing up Fairview, maybe by our mailbox, but it could have been in the driveway. I'm not 100% sure.
Not something you were particularly paying attention to?
No.
And at some point after you and your daughter and your husband and then Mr. Higgins comes along, about how long a period of time is it between your arrival in the home and then when Ms. McCabe and her husband come?
15 minutes, 20 minutes.
And as far as your nephew Colin, when he had left, was Ms. McCabe and her husband there yet?
No.
And when Ms. McCabe and her husband come, where is it that, while you're at your house, where is it that everybody sort of congregates?
They came in and they sat down at the kitchen table with Brian and his two friends. And then I believe my daughter, Caitlin, was sitting at the table as well.
And back at your home after leaving the bar, was there any drinking that was going on there afterward?
Yeah.
And about how long, skip forward to a little bit, people had left your home, about how long a period of time was it that people, from the time that you arrived back from the waterfall to the time that people sort of left and you closed down?
By the time everyone left, it was probably close to 2.
And who was the last person that left?
My daughter, Caitlin.
And do you know how it was that she left, or who, if anyone, picked her up?
Her boyfriend, Tristan, picked her up because, like I said, he was going to have to get up anyways overnight to do the shoveling, plowing thing. So I think she didn't want to get stuck probably at our house for the next day. So she had just said, hey, can you?
Okay, I'm going to end your answer there. Next question, Mr. Lally.
Hearsay, that's why.
Prior to your daughter Caitlin leaving, let me ask you this. As far as people leaving from your house, what was sort of the order of how people left and when people left?
I believe Brian Higgins left first, approximately 1:30-ish. Then Jennifer and Matt and Brian's two friends left 12:45, 12:50. And then, 1:45, 1:50, I'm sorry. And then Caitlin was probably closer to 2.
And when your daughter Caitlin left, who, if anyone, was left downstairs and sort of awake between yourself and the other people that lived there?
Just me.
So your son and your husband have both gone up to bed at that point?
Yes.
And at any point in time, so you mentioned that there were a number of people that were sort of around the table in the kitchen, correct?
Mm-hmm.
And
Yes, sorry.
where did anybody else go sort of around your house during that time?
I know at one point, my husband and his friend Brian were in our family room. So I kind of went in there and was talking to them We had some shelves on the wall that just had a bunch of pictures, old pictures from our wedding or when Brian was in the Marines. So we would just kind of look at them, laugh, and talking about them. We stood in there for a little bit talking. And then eventually we just moved into the kitchen area where everybody else was.
And to your knowledge, had Mr. Higgins been over to your house at any point prior?
He may have been at our house for a graduation party, but I wasn't sure if he had ever like been inside because the party was outside. It was a cookout. So I don't know if he'd been in that part of my house.
Now, as far as the outside of your house, at any point in time during the course of the evening, did you hear anything unusual, see anything unusual outside of your house?
I didn't.
At any point in time, did you go, were you aware of anybody coming to your house that didn't come in?
I was only aware at one point. I saw my son, I think, either looking out the window or at the door, and his friend Julie, she went out the side door, and I said, "Oh," to Brian, "Oh, is Julie leaving?" And he said, "Well, no, she had asked her brother for a ride."
Objection, Your Honor.
Sustained. So no conversation. And Mr. Lally's going to ask another question.
Okay.
So you saw
That voice was a female voice. I can't tell if that was on the prosecution side or on the defense side. So there have been instances where the attorney or the attorney's side that is asking a particular question then objects to the response by the witness. And sometimes it has been cause for mockery. That happened during the Deputy Heard trial. However, sometimes when someone is going outside of the bounds of the question, things like that, it can be proper to object to the answer and to request that it be struck. I don't know based on I couldn't recognize the voice if it was defense or prosecution, but that was interesting. So there's this tidbit about her son looking out the window and then his friend Julie going outside. At some point, I want to hear what she actually says about it.
your son's friend Julie go outside?
Mm-hmm.
Okay. And,
So that has to be a
Sorry.
yes or no. Okay.
Sorry.
and at some point, did Julie come back into the house?
Yes.
And about how long was it, if you know, that she was outside before she came back?
I don't think it was very long, couple minutes.
And over the course of the entirety of the evening, at any point, did anybody else, other than the people that you talked about previously, come into your house?
No.
And specifically, John O'Keefe or Karen Reed that you saw at the bar earlier that night, at any point in time on the evening of the 28th or the early morning of the 29th, did either of those people come into your house?
No, they never came into my home.
And at any point in time, even on that evening or that early morning of the 29th, were you aware that they were coming to your house?
I actually wasn't. I think when I was in the other room with my husband and his friend, I had missed the conversations about Jennifer reaching out with John or her texting him and him texting her about where we lived. I didn't even realize that was happening, that they had any intention to come.
Let me ask you a little bit about sort of going back to the waterfall just for a brief moment. Over the course of your time there, how would you describe sort of the tone or how was everybody at the waterfall?
It was fine. It was a nice night. It was nothing out of the usual, just had a good time.
So nothing abnormal, no arguments, no fighting or anything like that?
No.
Same question as it relates to back at your house now at 34 Fairview Road. How would you describe sort of the atmosphere back there?
Same thing. We were just hanging out, sitting around the house talking, having a good time, nothing crazy.
Now, after your daughter, Caitlin, gets picked up and she leaves, what, if any, how long did you stay up after that?
I think once she left, I just did my final cleanup of the kitchen and, shut the lights, and I went upstairs to bed.
And do you recall anything about locking the front door or any of the doors to your house before you went up to bed?
No.
Is that something that you would always do, typically do, never do?
It was type of thing where we have 5 kids, everyone's coming in and out at different times. Like the last person in was supposed to lock it, but then, we changed the doorknobs and immediately the keys got lost. It was just always a disaster so a lot of times the door was just kind of left unlocked.
And when you went up to bed, you share a bedroom with your husband, Brian, correct?
Yep.
And was he awake or asleep in the bed?
He was awake. He was just lying in bed watching TV.
Now, as far as over the course of that evening after you come up to bed with your husband, do you recall anything about him talking to anyone on the phone or any phone conversations or anything like that?
I do not.
At some point you fall asleep and then you wake up the next day, is that right?
Yes.
And turning your attention to later on that morning of the 29th. So you had gone to bed about what time?
Probably 2:30ish, somewhere around there.
And it's a little unclear for my question, but when you go up to your bedroom, about what time is that?
About 2-ish.
And so the 2:30 that you're talking about, is that sort of when you fall asleep?
Yeah, sometime around there.
And from that next morning, how is it that you wake up the next morning?
Well, at some point between 6 and 6:30 that morning, my sister Jennifer came bursting into my bedroom.
And comes bursting into your bedroom, is that correct?
Yes.
And what, if any, how would you describe your sister Jennifer, and how was she sort of acting at that point?
Well, she came in, my husband and I just kind of sat up in bed, and she's saying, he's out in the snow. We found him out in the snow. We don't know if he's okay. And my immediate thought was just that something had happened to one of my children, something had happened to one of her children. I couldn't imagine why she was in my bedroom at this time in the morning. And I'm like, Jennifer, what are you talking about? And she's like,
Objection. You're set.
All right, next question.
Your Honor, if I may? Can we approach?
Okay.
Okay. Time travel time. Yeah, so the female defense attorney is the one that is objecting, and her name is, Elizabeth Little. Sorry, I'm less familiar with her because, it's been all David Yannetti and Alan Jackson up to this point. So maybe she'll be the one to cross-examine, because that's the rule here, is that that's supposed to be the case. Whoever's objecting is also doing the other examining. Sorry, I also said it so quickly. Elizabeth Little, that's her last name.
Let me back you up just for a second and I'll get back. As far as when your sister Jennifer comes into your bedroom, do you know about what time that was?
between 6 and 6:30.
And it's fair to say that's not a normal occurrence?
No, it's never happened before.
And if you could just describe your sister Jennifer's demeanor when she first comes into your bedroom.
She was hysterical.
And she says some things to you, and then where did you go?
Well, I tried to ask her what was going on. What is she talking about? And she told us.
Objection, Your Honor.
No, I'm going to allow that.
So she told us, what had happened or what she had just witnessed outside. And we were just trying to understand what she's saying. Like I said, I didn't know if it was something that happened to one of her kids, one of my kids. And so I said, Jennifer, I don't know what you're talking about. So she finally was like, well, John, remember John from last night at the waterfall? And I'm like, what do you mean? How could you be outside? And she's like, you got to get up. The police are here and they want to talk to you. So my husband and I got up. I think I threw on a sweatshirt and we started to walk down the stairs. As we walked down the stairs into that foyer area, Officer Link was walking in the house.
And so that front foyer area would have been the front door you were talking about before?
Yeah.
And when you get sort of down to the bottom of the stairs, is it just Officer Lank? Are there any other officers with him?
It was just Officer Lank at that time. And the door was halfway open. I kind of pushed it open, looked out, and I saw like a cruisers and a couple of guys, standing out in the snow. And I said, Jennifer, where's John now?
Objection, Your Honor.
Okay, I'm going to ask you to move on, Mr. Lally.
Hearsay.
Objection sustained.
As far as when you looked outside, did you see any ambulance or fire truck or anything like that?
No, I didn't see an ambulance. I did see maybe 2 cruisers. I don't remember. I don't remember if there was a fire truck there. I don't think there was, but I'm not sure.
And as far as Officer Lank or any other officers, these are officers with the Canton Police, is that correct?
Yeah.
And where did they go once you opened the door?
So he came in the house, and I believe around the same time Jennifer's husband, Matt, had come. I assume she had called him or whatever. So it was me, Brian, and Jen and Matt, and Officer Lang said, can I come in? Can I talk to you guys? And we said, sure, absolutely. He came in, we sat at the table, and he was just kind of asking us all, okay, well, where were you last night?
Objection, Your Honor.
Okay, sustain. Next question, please.
Hearsay.
The table that you're talking about, where in the house did you talk to them?
That same dining room area.
And without regard to sort of content of the conversation, but about how long a period of time did that conversation with the officer go on?
I don't know, 45 minutes, maybe. I'm not exactly sure.
As far as how the conversation ended, at any point during the conversation, did yourself or your sister or your husband or did anyone ever sort of end the conversation or tell the officers to leave the home or anything like that?
No.
And you welcomed them inside once you realized what was going on?
Yes, absolutely. And I believe another officer had come in as well.
Now, after the officers leave from your home, what happened then?
So I believe they left and said that someone would be in touch with us, the state police or somebody. So they left, and we were all just kind of sitting there in shock. I'm asking Jennifer, what happened? How did you end up here? What's going on?
Objection, Your Honor.
Sustained. Next question, please.
Your Honor, as far as
I'll pull this up now. LK Ryden, the female attorney must be objecting to trigger the witness since it's visibly bothering her right. She must purposefully interior in the middle of a sentence. Well, I mean, these are legitimate objections. They are legitimate hearsay objections. Anytime she's talking about so-and-so said this, so-and-so said that, that is a hearsay objection. I mean, it also serves the purpose for the defense to be kind of throwing her off kilter, off balance. That helps, but there is a legitimate basis for these objections here, and I mean, yeah, they certainly are kind of throwing her off a little bit. They're getting her a little bit flustered in testifying.
may we approach just briefly?
Okay, all right, time travel time.
And so, Ms. Albert, without any sort of specifics of your conversation with Ms. McCabe, you had a conversation.
Really quick, also, the Lucian, I'm confused again. I thought the officers said they never went past the foyer. If they went into dining room, then officer did pass the entryway to the basement. Make it make sense, please. It's an inconsistency. These inconsistencies happen.
Conversation with her, is that correct?
Yes.
And about how long did that conversation go on for in this case?
With just her? I mean, we were all just kind of sitting around the table talking.
And just to be clear, when we say all, who is all at this point?
It was me, my husband, and Jennifer and Matt.
And at some point later on, did other people come over to your house?
Yes, at some point, my husband's friend Brian Higgins came over.
And do you know how he came to be at your house that morning?
I believe Brian called him to let him know. I mean, he had been with us the night before, and I think he had been friends with John and Karen, so Brian thought he should let him know.
And do you know about what time that was or how long it was after the officers left that Mr. Higgins came over?
Could have been 15, 20 minutes. I feel like he came somewhere around 7:38. And maybe the link had been done by 7:15, if he was around 6:30. I'm not really sure of the specifics.
And what happened then?
Then we were all just still kind of sitting there. Kerry, who is another person that was called that morning, she had been at the hospital, so she was kind of calling Jennifer, giving updates as to what was happening with John. So we were kind of waiting to hear how he was, if he was okay. Then around, I don't know if it was 8:30, I had noticed my sister-in-law, Julie, had pulled into the driveway, and I saw her get out, and she was putting a box of donuts in my son's car, whose birthday it was, because they had a bit between them where every year she did that. She got him donuts and she would leave them for him. So I saw her and I said to my husband, oh,
Objection.
Okay, not what you said to your husband. So wait for another question.
okay, sorry.
That's okay.
Spoke to her husband, and where did he go?
He went to the door because Julie was about to get back in her car and leave. And I thought that she should be made aware of what was going on.
And so your husband goes to the door, and at some point, your sister-in-law, Julie, comes in the house?
Yes.
And if you know about how long a period was Julie at your house initially that morning?
An hour or two. I'm not sure.
If you're not sure, you're not sure. So as far as people that were over your house that morning, do you have any idea sort of how long people were congregating around your house after that initial Miss McKay bursting into your bedroom?
Again, it could have been between an hour and two.
And at some point, you had mentioned that the Canton officers had indicated that you may be spoken to at some subsequent time by troopers from the state police, correct?
Mm-hmm. Yes.
And when was it that you, if you know, when was it in relation to this date that you spoke to anybody from the state police?
I wasn't interviewed for a couple days later.
And do you recall where you were when you were interviewed?
I was at my house.
Now, with reference to, you indicated that on the way back from the waterfall to your house at Fairview on the night previous, on the 28th into the 29th, it just started to snow, is that correct?
Mm-hmm. Yes.
Now, when you looked outside or opened the door for Officer Lank as he came into the house, what, if anything, did you observe as far as the weather and how it had changed in the interview?
Well, to me, it was starting to look like blizzard conditions. It was very windy. It was snowing. It was, the snow was starting to come down a lot now, and it was probably a couple inches accumulated. And it was,
Now, at any point in time over the course of that day on the 29th, did you yourself, did you go outside from your house into the front yard or the driveway or anywhere else?
I didn't.
And anyone else from your house other than the people coming and going? The people that live there, did you observe them going out into the front of the house area?
No.
May I approach the witness?
Yes.
Also, John O'Rourke, thanks so much for the super chat. What time did the autopsy say John died or the injury occurred? Could it have been the kids leaving if the time of death / injury was closer to 2 a.m.? Just thinking outside the box. So I don't think that there's any allegation about the kids leaving having done it, but I think that there is this discrepancy of, if all of these people left at like 1:30 p.m. 1:30 a.m. until 2 a.m., and he was lying out there, starting around 12:30 a.m., wouldn't they have seen him nearby? Now, to me, the photos of the lawn look a bit big. Some folks have said that, if you go there in person, it's a very different kind of view of the lawn. It's much smaller than it looks in the photos. And the jury has gone to actually physically see it. They did have a site visit. So, that is certainly an argument for the defense. There is like, how do you explain these people not seeing a dead body in the snow at that hour? Maybe their perception is impaired because they've been drinking. That's one explanation. It's dark out. It's snowing. There are some possibilities, but those need to be presented to the jury by the prosecution. So as for the autopsy, I don't know. I don't know the autopsy records. I think that the one thing that I do know, correct me if I'm wrong about this, chat, but I think that the one thing that I do know about the medical examiner's report is that they did not say homicide for his death. I think they said undetermined for his death, meaning they couldn't figure out the manner of his death. So that's an interesting point if that's the case. All right. Thanks again for the super chat.
Ms. Albert, I'm placing before you a series of 8 photographs. I just asked you to look at them,
Mm-hmm.
review them, and then just look up whenever you finish.
Are these already in evidence?
Fair enough.
Okay.
Okay. Thanks, Steve, for that confirmation. Couldn't figure out if it was from frostbite or injuries. Got it.
And just to ask you, ma'am, in general, in those photographs, do you recognize what's in those photographs?
Yes,
Okay, what do you recognize those to be?
that's my front yard.
That was your front yard when you lived at 34 Fairview Road?
Yes,
And what's contained in there, is that a fair and accurate portrayal of around the time of January 29th, 2022?
yes.
Your Honor, the Commonwealth will seek to introduce, admit. and-
Any objection, Ms. Little?
No objection, Your Honor.
Thank you. Yes, please.
With the court's permission.
Hold on.
Oh,
We need to mark these. How many were there, Mr. Lally?
8.
Okay. We're going to zoom. Oh, thank goodness we timed it all right.
Okay.
And again, Ms. Allen, do you recognize what's up on the screen there?
Yes,
And what do you recognize there?
it was my home at the time.
And from this photograph, do you see that front door area where the foyer is and the side door area that you were talking about on your house?
Yes,
If you could, using the laser pointer in your hand, just direct the jury's attention.
I would like to know what date and what time this photo was taken, because if this is the first time that I've seen this lawn with this massive patch of no snow in front of it. And if that's from the leaf blower thing where they said that they sort of moved snow out of the way little by little, if that's the case, then that does seem weird that they did not find any taillight pieces in this. It's I mean, unless it's like, on this far left side over here that they were found where they didn't dig under the snow. That's weird. It's weird that they wouldn't have found any pieces there. Maybe they can explain it. If they have a reasonable explanation for it, then that's different.
Where each of those are and indicate where they are.
That would be the very front door, and then the side doors over here in between.
And as far as the sort of what's in the front portion of this photograph, do you recognize that as if I'm standing and facing as this photograph is your house,
Mhm.
where you lived at 34 Fairview Road? What, if anything, do you have as sort of a landmark or an item that you observe in that sort of left area of the yard?
Flagpole?
Is there a fire hydrant there as well?
Yes.
And do you see anything as far as like?
And really quick, also, Steve, this also is a good point. It also makes sense why you wouldn't see a body from the house when leaving. There is a bit of a hill there behind it, right? So, I can see that from, folks that are leaving the house and then going down the driveway, not seeing it from that perspective. Again, I haven't gone there myself in person, so maybe it looks different being there in person, but that's an interesting explanation too, or an interesting point.
Or something like that?
Yeah, I believe there was some electrical box that I don't think we ever actually knew what it was or what it did.
So fair to say all the years that you lived there, it's not something that you utilized or even knew what it really did.
No.
Now, this particular area of the yard, in its relation to the house, was that a part of the yard that was used or utilized by the family all that much when you lived there?
No.
And that part of the yard where the fire hydrant, flagpole, that is, how close is that to sort of the next door neighbors abutting of the property?
It's pretty close. It's almost, I would say, on the, close to the property line.
Now, as far as from the side of the road, in between sort of the curbing from the roadway and your front lawn, there's nothing there as far as a sidewalk or anything like that. Is that correct?
Right.
And the curbing that's between sort of the roadway and the front lawn, how would you describe that? Is it a sharp curb, rounded curb?
It was kind of a rounded curb.
Now, with reference to your driveway, do you see that depicted in this particular photograph?
You can't really see it in the picture, no. But I mean, it's would be over here.
Thank
you. Yeah.
If I could direct your attention to the next photograph that you have before you.
Mm-hmm.
Just gentlemen, if I can have that one up on the screen as well. And again, Ms. Al, would you recognize what's up on the screen?
Yes.
And this is just another photograph of your home as it was around January 2022 at 34 Fairview Road.
Yes.
And from this photograph, do you see now sort of the driveway and where that is?
Yes.
And if you could just indicate to the jury sort of where in this photograph that would be.
The driveway was right here. The two garage doors, and then there was driveway right along here.
Now, in reference to that driveway, or in reference to your family at the time that lived at the house, about how many cars would there typically be when everyone's home parked in the driveway?
Could have been 4. Let me think. 1, 2, 3. I think 4.
And who would those vehicles be typically operated by, and what kind of vehicles are we talking about?
I had my car, which was a Cadillac SUV. My husband had his work car. And then we had, I think, a Ford Explorer. And then the kids were driving a Ford Escape, maybe?
All sort of bigger cars, all sort of SUVs? Is that
Yeah.
correct to say?
Yeah.
If I could direct your attention to the next photograph. And again, what's up on the screen, is that what you have for you as the next exhibit?
Yes.
And just for the record, if you could read the number that's on that photograph now.
60?
And again, what's up on the screen, is that just another depiction of your home at that time?
Yes.
Now, when you open that door and Officer Lank is there and you invite him into your house to talk, you said that you saw some cruisers, correct?
Mhm.
Where in relation to your property were the cruisers when you opened the door and saw them? If you could direct the jury's attention to this photograph.
I believe they were right here. Somewhere here.
If I could direct your attention to the next photograph that's in there.
Yep.
And again, the photograph that's up on the screen, is that what you have before you?
Mm-hmm.
And again, I'm sorry to keep asking you
Yes,
to do this, but
yes.
if you could read the number that's on the photograph.
63.
And so exhibit 63 up on the screen, if you could describe to the jury sort of what part of your property or abutting property are we looking at?
I believe our property ended, somewhere along here.
So right about in the general area of the electrical box and fire hydrant you were talking about?
Yeah. Yep.
And that next door residence there, do you know offhand what the number was for that?
I don't. Maybe 36? I'm not sure.
Somewhere in the vicinity of your number 34.
Yeah.
And if I could direct your attention to the next photograph.
Mm-hmm. 64?
Thank you.
Yeah.
On pace. So with respect to this photograph, as far as the sort of side door, do you see that in this photograph?
Yeah, the side door would be right here.
And there's sort of another door off to the right of the photograph, is that correct?
Yep, that door would go into the garage.
And typically, at least around this time, January or late January 2022, as far as the vehicles that you were talking about, would any of those vehicles go in the garage, or what was in the garage?
The garage was a little bit cluttered, so if there was a storm coming, we would try to arrange things so we could at least maybe get one or two of the cars in there, but otherwise we didn't put the cars in the garage. Only if it was gonna, be a storm, we would try to get some of them out of the driveway.
And with reference to these specific dates, January 28th and the 29th, and this specific storm, do you recall anything as far as putting vehicles in the garage on those dates?
I don't. I'm not sure. I'm not sure if we had maybe put mine in there because I had gotten picked up that night. I'm not sure.
And I believe, is there one more photograph that we want to talk about?
58.
May I approach, John?
Yeah. No. Okay.
Now, in addition, let me ask you this. At this time in January of 2022, did your family have any pets?
Yes,
Ooh,
And,
pets.
how many pets did you have?
we had one. We had a dog,
What was the dog?
Chloe.
And what type of dog was it?
She was a German Shepherd mix.
And how long had you had the dog at that point?
So she just said that the dog was a German Shepherd mix. I thought this was a former canine, which my impression has always been that they have to be purebred. Folks can please correct me about that if I'm wrong. On either part of that, either the canines can be mixed or that this is not a former canine. Let me know.
About 6 years, I believe.
And do you recall sort of when you got the dog, how you got the dog, or where you got the dog from?
We got the dog from a shelter in Texas.
And what type of, so shelter, or fair to say it's a rescue dog?
Yes.
And where did the dog typically go within the house?
It was when it was allowed anywhere in the house.
And as far as nighttime, would there be any sort of particular pattern of where the dog would sleep?
Yes, at nighttime when we went up to bed, it came up with us and it slept in our bedroom.
And at any point in time, during the time from when you returned from the waterfall to your home, where was the dog at that?
Well, the dog had been up in the room, and I believe my husband, when we first got in, brought her down to let her out to go to the bathroom.
And when the dog went out to go to the bathroom when you lived at 34 Fairview Road, where would the dog go? How would that?
Well, she pretty much she knew the door where to go. So when she had to go, she would go to that door and she would just go out and run in the backyard and go and on her own.
So on her own, and someone would sort of stand at the back door?
Yes.
And the back door that we're talking about, what kind of door is that?
It's a regular door.
I mean, is
Like-
it a door that opens? Is it a sliding door?
Oh, yeah, no, like just a regular door, and it had,
Why
I
do
think,
we
a
need to
storm
know
door,
that?
behind it.
And the backyard area of your home at 34 Fairview, when you lived there in around January 2022, how was that enclosed at all?
It was fenced in.
So dogs couldn't get out if everything's closed up in the backyard.
Yes, as long as the gates were shut.
And as far as that particular evening, after you returned from the waterfall, you indicated your husband let the dog out. About how long a period of time was the dog outside?
I believe it was pretty quick. She went, did her business, and came back in. I think she might have walked around the kitchen for a minute or two, and then I think you just brought her back upstairs.
And to your knowledge, did Chloe the dog, did Chloe go outside at any other point over the course of that evening?
No.
I mean, if it's the backyard every time, who cares?
Now, at some point, obviously you've moved from 34 Fairview to North, correct?
Hmm.
And when about was it in relation to this incident of January 29th, 2022 that you moved?
We moved in April of 2023.
And what, if any, plans or discussions were there in reference to moving prior to January 29th?
Objection, Your Honor.
So not the specifics, but generally, not the conversation.
We had always planned to move, but it was in our plans that, what kids were starting to get older, we were looking to possibly downsize. So at the end of 2021, my husband's brother had sold his house.
Objection.
No, I'm going to allow that.
Yeah, there's no hearsay or anything.
My husband's brother had sold his house and got a good deal for it. It sold pretty quickly. The market was really good at that time. So we just started thinking, hey, the kids are getting older. A couple of them had already moved out. We weren't going to be able to stay in that house. It's like a 5-bedroom house. Once our kids were gone, my husband and I wouldn't have been able to maintain that. Needed a lot of work. We couldn't afford it. So we said, maybe now's the time we should put it on the market and see what happens. So I think in November, December.
So hold on. Next question, Mr. Lally.
Yeah. She had finished that answer. Now, I will say, so far, this answer is reasonable. It's reasonable to say, look, we're getting older. The house is big. All of our 5 kids are grown. They're moving on to, to college, and maybe they're boomeranging back to us, but we don't really necessarily want to encourage that. We don't have to accept them back. They're adults. So to say, like, we don't want to be taking care of all of this space for all the time. It takes a lot to keep it dust free and vacuumed and all this kind of stuff. So, and what better time to downsize than, in a very hot market to sell a house, where there's a housing shortage and all this other stuff. So I definitely get that. And I know folks have commented on the price that it sold at. I'm wondering if they're going to address that as well, because otherwise on cross-examination, the defense, I'm sure, is going to bring that up to make it look a certain kind of way. So I hope for the prosecution's sake that they do bring it up and they have an explanation as to what happened.
Sorry.
No, that's okay.
So you put it on the market, it sold, and then you moved.
Objection, leading.
The objection sustained. Ask a non-leading question.
When was it that the sale was finalized?
Got a basis for that one.
April of 23.
And as far as selling the house, what, if any, relationship did that have to what occurred on January 29th, 2020?
It had no relation
Of course.
to it. We had already had thoughts and plans of doing it before that happened. We had reached out to a realtor in the end of 21.
May I have one moment, Your Honor?
Yes.
I have nothing further for this witness, Your Honor.
All right, Ms. Little?
Okay, that's interesting to me that they didn't go into the price. If defense goes into it, it's gonna look a little weird to the jury.
Good afternoon, Ms. Albert.
Hello.
You were at the Waterfall Bar and Grill on January 29th for approximately 4.5 hours. Is that correct?
I was there from, say, 7:45 till about midnight.
So about 4 hours?
Yeah.
And you were there with a group of individuals, including Brian Albert, Jennifer McCabe, Matt McCabe, Julie Albert, Chris Albert, Caitlin Albert, and Tristan Morris, and then were later joined by Brian Higgins, correct?
Yes.
Okay. You testified that John O'Keefe and Karen Reed joined your group around 11 p.m. Is that right?
Approximately.
I do wish she'd speak more into the
Over the
mic
course of
or
those
speak up.
4 hours that you were there, did you see any sort of tension whatsoever between John O'Keefe and Ms. Reed?
Well, no, they were only there for an hour when I was there, but I didn't have really any interaction with them. But no, I didn't see anything.
So based on your observations, everyone appeared generally happy and in good spirits, correct?
Yes. Yep.
At any point while you were at the Waterfall Bar and Grill, did you observe Karen Reed stumbling, slurring her words, or otherwise appearing to be under the influence?
I did not, but again, I never engaged in any sort of conversation with her.
Did you observe your husband and Brian Higgins engaging in sort of practice fighting techniques while you were at the Waterfall Bar and Grill?
I saw them fooling around with each other, yeah.
Okay. Your Honor, if I could show just a screenshot of a video that's been previously marked.
A screenshot of it? Sure.
May I approach you, Mr. Reporter?
Yes, so can you take this down just until the witness has it, please? I thought you were just showing the screenshot. You want to show it up here?
Yes. If that's
Okay. So what are you doing
Should
with
we
it?
mark that as an exhibit? Or
I don't think there's a need to. I thought you were showing something to the juror that you were just. Yeah.
if I could show you this photograph.
So she's a little bit less experienced, I think, than Alan Jackson and David Yannetti, or maybe she's just, nervous because this is a super high profile trial. This is her first time really engaging in the trial itself. I know that she's participated quite a bit in some of the pretrial hearings, but this is her first time. She might be feeling a little bit rusty. It might take her some time to sort of warm up a little bit, but that, she was trying to get that admitted as an exhibit. Steve, thank you so much for this context. She's a partner at Alan Jackson's firm, which means that she has trial experience. So it might just be the fact that this is such a high profile trial and she hasn't quite warmed up yet. It could be, but she definitely seems a little bit less experienced than someone like Alan Jackson, who's been around the block for I don't know, decades, I guess. Like he worked as an LA County DA at the same time that Emily D. Baker did. So I don't know, how long he had been working there when she started working there or whatever. But this is just someone who is a little bit less experienced. That's fine. It's fine. So a little bit of a rusty start, but that's okay. We'll see where this goes.
Mm-hmm.
All right, so we will mark it for
Oh,
identification.
sorry.
Ms. Albert, do you
So hold on, so we'll mark it for identification. So we'll take it from the witness for a minute, please.
Sorry.
We'll mark it for identification, but this is incorporated in what exhibit number?
I believe it's exhibit 53, Your Honor.
All right, just so our record's clear.
Thank you.
Yeah, and LK Ryden, yes, I think she's from California if she's from Alan Jackson's firm.
Thank you.
So yeah, this would be a new courtroom. for
All
her
right,
as
so
well.
now you can,
Your Honor, if I may, I haven't seen what the witness is looking at.
okay.
Thank you.
Could be nerves. We'll see.
Okay.
How
Thank you
things
very
kind of
much.
smooth out, maybe. Thank you.
All right, so you want to display it on the screen now, Ms. Little?
Yes, Your Honor.
Okay, sure, go right ahead.
Ms. Albert, do you see the two individuals sort of in the closest frame to us with their backs turned to us? Two males?
Yeah.
I know it's kind of hard to see.
Yeah.
Who is the man that has just been zoomed in with the logo on the back of his sweatshirt?
I believe that's Brian Higgins.
Okay. And then the person with that sweatshirt is, you said Brian Higgins?
I think. Yeah. It's a little hard to tell.
Over the other individual who's standing right next to him. I know this is kind of hard to see because the number's blocking it.
Yeah.
But does that appear to be your husband to the left, kind of in a fighting stance?
Yeah, I think so.
Okay. Ms. Albert, when your husband drinks, does he often
So I'm sorry, are we taking this down or keeping it up?
Yes, Your Honor, you can take it down.
Okay, thank you.
Ms. Albert, when your husband drinks, does he often get into sort of these practice sparring, practice fighting stances? Is that common for him?
Objection.
No, I'm going to allow it.
No, I don't think so.
So this type of behavior was unusual for him.
No, I think they were just fooling around. I don't think there was anything much to it.
My question was, is it unusual for you to see him sort of practice fighting?
I wouldn't call that practice fighting. I think they were just fooling around. And yeah, maybe I've seen him do that other times, but it was fooling around. They weren't practicing.
Let me put this a different way. You do know that your husband is a highly trained fighter, correct?
Objection.
I'll allow that.
Absolutely not.
Your husband has no fighting experience whatsoever.
A highly trained fighter? No, he's not.
He has boxing experience, correct?
Objection.
So I'm going to see you at sidebar on this, please.
I think the question is a speculation issue. Let's time travel again through the sidebar.
Being
Oops,
experienced.
sorry. I went too far.
Ms. Albert, your husband has boxing experience, correct?
Yes.
He also has fighting experience from his training in the military, correct?
I don't know what fighting experience from the military means.
Well,
I mean, he was
hand
in the Marine
combat.
Corps. He was out of the Marine Corps in 1992.
But he had training through the Marine Corps and through the Boston Police Department with fighting and defensive tactics, correct?
I assume so.
Ms. Albert, you testified earlier that you left the waterfall around, I believe, 11:45. Is that correct?
No, I said I think closer to 12.
Okay. Could I show you what's been previously marked as Exhibit 53? Your Honor, could I have permission to publish Exhibit 53?
Okay.
And Mr. Bates, if I could have you start the video at 5:42.
He's probably going to give a timestamp for when she actually left.
If you could pause. This video,
No, I don't.
do you see the woman that's in the lower quadrant? Do you recognize that individual at all?
I don't. It's so I can't tell who that is.
I know this is not the best video, so I'll play a little bit more and see if you might be able to recognize it. You don't recognize who that individual is?
I mean, it could be me. I'm not sure. I can't really tell.
All right, so this is an instance where the video has to speak for itself, right?
Understood, Your Honor. You could play just for a little bit longer. Good pause. Did you recognize the woman that just sort of walked forward?
Yes. Now seeing the coat, I recognize that it's me.
And did you see what was in your hand when you walked by?
I don't.
You could play just a little bit more. Ms. Albert, do you say you appear to be holding something?
Yes.
What is that?
Looks like a can.
And what time is that video taken?
11:58.
That would have been approximately the time that you were leaving the Waterfall Bar and Grill.
Yep.
You guys had a fun night. It looks like you kind of grabbed the White Claw. You're about to leave. Is that correct?
Yes.
Okay. You testified earlier that you got home.
So can we turn the lights back on and, okay.
Thank you, Your Honor.
Interesting. So leaving with a cocktail glass. I did not see that coming.
Let me switch gears a little bit. You testified earlier that there are 4 cars that are usually parked in the driveway at 34 Fairview, correct?
Yes.
And you listed at least the make and model of about 3 of those vehicles.
Yep.
Do you recall that?
Yep.
You said there's a Cadillac that usually is parked in your driveway, there's a Ford Explorer, and there's a Ford Escape, correct? But you also said there's a 4th car. That's your husband's work vehicle. correct?
Yes. Yep.
What type of car is that?
That's a Ford Edge.
A black Ford Edge.
Yes. Yep.
Is there a reason that you didn't want to state or commit to that in front of this jury when you originally testified?
No, there's no reason. I was just trying to think of all the different cars. We have 5 kids. We've had a lot of different vehicles. I was just saying it as I remembered it.
Fair enough.
News coverage in this case has revealed the importance of a Ford Edge.
Objection, Your Honor.
Sustained.
Referring to news coverage.
In your mind, a Ford Edge has significance to this case, doesn't it?
Objection, Your Honor.
No, can you answer that? Does a Ford Edge have significance in this case to you?
I've heard it talked about. Yeah.
And what you've heard talked about is that an eyewitness saw a Ford
Objection, Your Honor.
Hearsay.
I'm going to stop you on that. The
That's
objection
hearsay.
sustained.
And you would understand that
Albert,
Ford
you
Edge.
know there's significance to the Ford Edge, and that's the one
Objection,
thing
Your Honor.
that you did not mention in your initial testimony, correct?
So I'm going to allow that question.
Yeah.
Can you answer that?
I just was trying to think of all the different makes and models. I did not purposely say that.
Okay, so even though she's not really answering that question, really, dang it, lost my earbud. So even though she's not really answering that question, she is. The defense is opening that question for the jury to think about, to be like, well, what's the significance of the Ford Edge? Like, that's now a new mystery for the jury to think about, to try to solve with future testimony. So even though she's not quite the witness is not answering the actual question and not really giving what the defense would love to get, it's still helpful to the defense. Also, Loquaria, this is a good question for the moment. Is he supposed to object before she finishes her question like that? No, he's supposed to wait until the end of her question, but he may have thought that she was finished asking her question. But it was good on her to continue asking it. Don't get thrown by it, because it ended up, he was overruled anyway. Okay, let's continue on. And other questions I am saving for after this portion. Hey.
Where did your husband strike that? You testified earlier that you weren't sure exactly where Brian Higgins parked that night when he arrived at your house, correct?
Right.
And you said, I'm not sure, but then you gave a pretty vivid description about him being parked, you think, in front of the house by the mailbox facing away from your residence, correct?
Right. Yep.
Is that statement something that's from your personal recollection, or for something that you've discussed with other witnesses in this case?
No, it's from my personal recollection of what I'm pretty sure I remembered. He pulled in first, he backed out so we could pull in, and then I'm pretty sure he pulled out and parked along the curb where the mailbox was.
So you haven't discussed that statement with any other witnesses in this case?
I don't remember. I don't. I don't think so.
You testified earlier that when you arrived at 34 Fairview, your son, Brian Albert Jr. was there, Julie Nicole was there, Sarah Levinson was there, and that your nephew, Colin Albert, was also present, correct?
Yes.
Okay. Can you describe sort of your interaction with Colin Albert when you walked in the door?
It was literally, I was coming in. I think we almost bumped into each other. I said, I didn't realize he was there. I said, hey, what are you doing here? He said, oh, I just come by to see Brian, but my ride's on its way. I'm about to leave. And I
Okay.
said, oh, okay.
Colin Albert now.
And I said, all right, I see ya. And he just kind of continued on. I think he must have went out the door.
So when you first testified, I believe you stated that you saw Colin seated at the table with Brian Jr., correct?
When I testified when?
Earlier today.
I don't believe I said
And
that.
shortly after he got up.
No, I don't believe I said that.
You never said that he was initially seated with Brian Jr.
No, I'm pretty sure I said when I walked in, I immediately saw him.
So when you walked in the door, you're saying he was already leaving to go get his ride, correct?
He was standing and looked to me like he was getting ready for someone who was coming to pick him up.
Got it. And when you pulled up with Brian Higgins and Brian Albert, that all happened around the same time, correct?
Yes.
And you have never mentioned seeing any other vehicle waiting outside the house for Colin when you arrived, correct?
No.
You didn't observe another vehicle outside the house.
No, I'm not saying he said to me, my ride's almost here. I'm leaving. So I didn't see anything outside about his ride.
And it was cold outside that night?
Yeah.
So he sort of walked out the door before his ride arrived?
I don't know if he went and stood and waited by the door. I came in the house and like I said, I immediately said hello to my son, his friends. I went and started doing my cleaning and I didn't really pay attention, but I assume he left because I never saw him again.
So you're not sure if he was sort of standing by the front door?
I'm not sure. I mean, he could have been standing there waiting. He said his ride was about to be there.
Okay. But you didn't see him?
I did not see him leave.
You testified that your German Shepherd, Chloe, was also at the house when you arrived home on January 29th, correct?
Yes.
She's a large German Shepherd.
Yep, about 70 pounds.
She's not great with strangers.
I wouldn't say that.
You wouldn't say that it's kind of a poorly worded question.
Double
Would you
negative.
say that she's good with strangers?
I'd say she's fine with strangers.
Fine with strangers. Okay.
Yep.
She's definitely not good with other animals, is she?
No, she did not like other dogs.
Chloe actually has a well-documented bite history, doesn't she?
Objection.
Does she?
With dogs, a couple dogs, yes.
Ms. Albert, she also has a bite history with humans, doesn't she?
Objection.
Ask that differently.
Ms. Albert, Chloe has injured other humans, hasn't she?
Objection.
I'm going to allow that.
Yeah.
In one incident in May of 22, when she got out and was fighting with another dog, the woman whose dog it was tried to break up the two dogs. And while she was trying to break up the two dogs, she got injured.
There were actually two individuals who were injured in that incident, correct?
Well, there was two women, but I believe just one woman, from what I understand, had an injury from Chloe. The other one may have fallen or something, but I'm not sure 100%.
There
That's
were
not
two
great.
women who were actually taken to the hospital after that incident, correct?
Yes, a neighbor had called the police or called an ambulance just to make sure they were okay.
And you mentioned that Chloe had actually escaped from the backyard
Mm-hmm.
in that incident.
Yes,
And that happens from time to time at your house, correct?
it had happened a few times, yes.
Hmm.
And Mr. Albert let Chloe out when he arrived that night, correct?
Yep.
Okay. So now that testimony earlier about the backyard, now I understand why it matters.
Ms. Albert, you don't have Chloe anymore, do you?
Nope.
In May of 2022, 4 months after Mr. O'Keefe's death, you got rid of your family dog of 6 years.
Objection.
So is that true? Is that when you got rid of your dog?
I did not get rid of my dog. I rehomed my dog.
Your dog
Potato,
is
potato.
no longer in the Canton area, correct?
No, but I know where she is. She's in Vermont. And that previous testimony, that information has all been given. So if she was ever needed for anything, we know where she is.
Was that testimony given to the defense?
Probably.
Was I present at the hearing?
The fact that this is only coming out on cross-examination is bad for the prosecution. Why didn't they talk about this on direct examination? That is dumb, 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 dumb. This should not be coming out on cross-examination. They should have talked about it on direct. They knew this was coming. They absolutely knew this was coming. And it would have sounded much better. I mean, it still doesn't sound great, but it still sounds better coming out on direct rather than cross-examination.
Hearing where you testified about this?
Objection, Your Honor.
Sustained.
Your Honor,
She's
permission
definitely
to
getting
repeat.
defensive. I mean, to rehome an animal, I've had to deal with that too. It sucks. It usually happens because, I mean, I don't know, different pet owners are different, I guess. There are, all kinds of people out there with their pets, but usually we want to hear a decent explanation for why a pet was rehomed. It does sound a little suspicious. It does sound a little bit.
Don't be suspicious. 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 John Ralphio? God.
Yeah, it does. It does, right? Sorry, I didn't mean to bring up chats onto the screen during that. I was trying to save some questions. It would have sounded better coming out on direct. But also his objections to this stuff and being overruled, it just sounds like, please don't talk about this. Please don't talk about this. Please don't talk about this. We don't like it. Okay. Mike Olson, question: when it is all this extra fluff that is supposed to show what fine and all American patriotic people are, does that make you more suspicious that there is something behind the mask? Not necessarily. Sometimes there's not really anything to it. It's fairly common for people to bring up these things that are beneficial, a casual reference to charity work or a casual reference to, this and that is a positive thing that people admire and people like. So, but if there's a heavy emphasis on it and it doesn't seem necessary, yeah, maybe.
Ms. Albert, you're aware that we actually sought records regarding Chloe and her bite history, correct?
Objection, Your Honor.
Was it from this witness?
It was.
That's a yes or no from there. Yes or no?
Well, it was from a custodian.
Okay. I'm going to sustain the objection.
You know what? Because the objection is speculation. How would this person know if the care is under someone else's care? How would this witness know? So what she needs to do is lay a foundation of okay, you talk regularly with the custodian, right? And you just said, on cross-examination a few minutes ago that, you were in regular communication with them, and anything that was needed from the dog, you were able to provide. If there were any requests from the custodian, they would inform you, et cetera, et cetera. And then you can lay the foundation of are you aware from the custodian of the dog that there was a request made to them for this information? So maybe she'll go that route.
All right, Ms. Albert, I want to direct your attention back to the early morning of January 29th.
Mm-hmm.
You testified that everyone who arrived at your house just after midnight was sort of generally gathered at the table in the kitchen area, correct?
Yes.
And over the course of that evening, you had never heard any sort of disruption inside, correct?
No.
You didn't hear a crash. Certainly
There
never
needs
heard-
to be an answer.
I was really hoping that she was going to lay that foundation because I wanted to hear it. I wanted to hear it come out.
Sorry, no.
You certainly never heard any screaming or yelling,
No,
and you never heard the screech of any brakes outside, correct?
correct.
Okay. On July 20th, 2023, you testified before a grand jury, and Mr. Lally was not there, correct? And ADA McLaughlin was also not there, correct?
Okay.
Do you recall that?
Yes,
And you were specifically asked during the course of that hearing where everyone was positioned around the table that night.
mm-hmm,
Do you remember that sort of line of questioning?
yeah,
And you explained that your sister Jennifer was seated next to Brian Jr.
Objection. Is there a question?
We're getting that question, so go ahead.
You were very specific about kind of how people were seated at that table that night. Do you remember that testimony? You explained that Jennifer was seated next to Brian Jr. and Matt McCabe was across from him. Do you recall that?
Yep.
But when you were asked where your husband and Brian Higgins were positioned at the table, you weren't able to place them there. Isn't that true?
because I don't believe they ever sat at that table.
And what you told the grand jury during that hearing was that at least at one point, they had left the room and they were outside of your view, correct?
I'm not sure I said that.
Told the jury that you were cleaning and you weren't sure where they went, correct?
Well, initially, when I first came in the house and I was doing my thing, I don't remember exactly where
And
they were.
you told the grand jury that you don't recall seeing them at the table, but you don't recall where they went because you were kind of focused on cleaning, correct?
Right.
And there was one point at which you said that you joined them in family
Yes.
room. Is that right? But while you were cleaning, you said, I don't really know what they were doing, but they weren't there, correct?
Yes.
So you recall your husband and Brian Higgins left your view and went to some other place in the house that evening, correct?
They could have.
Ms. Albert, how many steps is it from the front door to the basement?
Steps.
It's a poorly worded question. I will rephrase it. When you open the front door of your house,
Uh-huh.
how many steps does it take to get to the door to the basement?
4 or 5.
I think she means the bottom of the basement.
You testified earlier that Brian Higgins left 34 Fairview first, correct?
Yes.
Then Matt McCabe, Jennifer McCabe, Sarah Levinson, and Julie Nagel left together, correct?
Mhm. Yes.
And the very last person to leave your house that night, you said today under oath, was your daughter Caitlin, correct?
Yes.
And you said she left your house close to 2 a.m. Is that right?
Yep.
Ms. Albert, that's not what you told Sergeant Lank on January 29th, 2022, is it?
I don't recall what I told him.
Would it refresh your recollection to take a look at your statement to Sergeant Lank?
Sure.
May I
Interesting.
approach the witness, Your Honor?
Yes.
We have an inconsistency. When do we get to lunch? Ah, okay. In about 15 minutes. Okay, we're gonna time travel a little bit. Okay. Oh, and they are approaching. There might be an objection.
I'd like you could read
Oh,
this.
sorry.
May I approach?
Yes.
Okay. I'd like you to take a look at page 2.
Mm-hmm.
And you don't need to read it out loud, but if if you could read this very last paragraph here,
Down hit 7? Or,
actually, this section right here,
Okay.
the second paragraph to the bottom. And you
mhm.
don't need to read it out loud, just look up once you're done.
And are you going to clarify that, Ms. Little? Statement?
Oh, how can I approach, Your Honor?
D-
Ms. Albert, this is just a police report containing an interview that was conducted, correct?
Yep.
With Sergeant Lank on January 29th, is that right?
Yes, the morning of.
Thank you. Have you had a chance to?
Yes,
is
yeah.
Your recollection, excuse me, is your recollection refreshed?
Yep.
Isn't it true that you told Sergeant Lank that your daughter left at 12:15 on January 29th?
Do not recall saying that. I've maintained in every interview testimony I've had that she was the last to leave. So I don't know, it was very confusing that morning. Officer Lank was trying to ask everybody, where had you been? Where had you been? When did you get here? When did you leave? I don't know if somehow it was misconstrued, but I've always maintained that Caitlin was the last to leave.
And that's because Sergeant Lank was talking to everyone at the same time, correct?
Yeah, I mean, we're sitting around the table. It was a little, everyone was, we're all in shock and
This was
a
a
little
group
confusing.
statement.
It was more
Those
of
are
a
common.
Conversation than an interview, is that right?
I guess you could say that.
May I approach?
Yes.
Okay, so daughter went from first to leave to last to leave.
Ms. Albert, do you deny saying that to Sergeant Lank?
I don't believe I said that. I think maybe someone was saying, oh, Jen and Matt got there at 12:15. He misunderstood. It got misconstrued later in his notes. But I've always said, in any other time I was questioned, that my daughter was the last one to leave. So I don't,
So you weren't trying to protect your daughter?
no.
You were forthcoming about always providing the troopers with information about the individuals who were present that night.
Yes.
Ms. Albert, you and your family discussed this case at length before your interviews with law enforcement, correct?
Objection.
I'll allow it. Did you?
Of course, we discussed the case, but just everything that was going on, we were trying to figure out what happened.
And you testified that you spoke to Trooper Proctor on February 3rd, 2022. Is that correct?
Yes.
That would be 6 days after this occurred. Is that right?
Yep.
And that's the very first time that you were ever interviewed by Massachusetts State Police.
Yes.
Correct?
Yep.
Aside from that sort of conversation you described with Sergeant Lank.
Yeah. Yep.
When you spoke to Trooper Proctor on February 3rd, 2022, you left a lot of names out of individuals who were present at your house on the morning of January 29th, 2022. Isn't that correct?
I'm not sure who was left out.
Did you tell Trooper Proctor that your son, Brian Albert Jr., was home that night?
Was home the night of his birthday, or what do you mean?
Yes, the night of his birthday.
Well, yeah, he was home with his friends.
Did you tell that to Trooper Proctor?
I assume I did.
So if it wasn't in his report, that would have been his mistake?
Objection, Your Honor.
Sustained.
Did you tell Trooper Proctor your daughter, Caitlin Albert, returned home with you after the waterfall?
I believe so.
Did you tell Trooper Proctor that your son had 2 female friends at your house when you arrived?
I believe so.
And notably, did you tell Trooper Proctor that Colin Albert was present at your house?
I probably didn't, because anytime I was questioned about who was there, to me it was who was there afterwards, hanging out from like the 12:15 point on. I didn't consider Colin as being there because I literally crossed paths with him. He left, and I didn't consider him being a part of the group that was there.
That's a little bit of a weird
Were
explanation.
you asked who was at the house that night?
I assume he asked that. But I also didn't mention the people that my son had previous, because I didn't consider them as part of
You didn't
the
consider
people
them
that I
as
was
having
with
been
when
there
I
that
got
night?
home.
You never
Hmm.
mentioned Colin Albert to Trooper Proctor, correct?
Correct.
And you never mentioned Colin Albert to Sergeant Lang.
Correct.
Ms. Albert, you knew that if you gave Trooper Proctor the name of your nephew, that he would have to interview him, correct?
Objection.
All right, I'm going to sustain that objection.
Yeah, it's speculation.
You didn't want your kids or your nephew to have to tell the police what they saw, what they heard, and what they did that night.
Objection.
I'm going to allow
Yeah, she
that.
can answer
Is
that.
that true?
That is not true.
Doesn't matter what
You
she
never
says
told
to that.
Trooper Proctor about Colin Albert.
I didn't mention Colin because I didn't consider him as part of the group that we were hanging out with after the waterfall, because he left as soon as I walked in. I didn't even think of him.
Didn't even think of him.
No.
Didn't think it might be important for the state trooper who was investigating this case to know the individuals who were leaving at the precise time that Mr. O'Keefe and Ms. Reed arrived at the house.
Objection.
Sustained.
Ms. Albert, what's the first thing you remember waking up to on the morning of January 29th?
My sister bombing into my bedroom.
Okay. Your Honor, if we could approach.
Okay, approach sidebar or you? Okay.
Yes.
Yeah, the Lucian, she is every time she's caught in an inconsistency, she like throws out all of these words to explain. And it just makes it seem like she's trying to justify it. And that looks dishonest. Whew. My goodness. Time travel.
Ms. Little, we're going to mark what you have in your hand for identification.
Yes, we will all point and laugh at it. We're going to mock it.
Thank you.
Robert, I'd like to show you a photograph which purports to be.
Just show her the photograph.
Ms. Albert, do you recognize that photograph?
Yep.
What is it?
It's a picture of my house.
Does it appear to be generally to scale?
Yep.
Do you recognize sort of the flagpole in the yard,
Yes.
the house,
Yep.
the driveway?
Mm-hmm.
And that looks
Yes.
accurate. And that looks accurate in terms of scale, correct?
Yes.
Permission to publish?
Sure.
I wonder if it's the layout of the house or something.
Ms. Albert, where is your bedroom located?
Interesting question.
Want me to show it?
Yes, if you could explain.
Right up here.
So your bedroom is in that upper left-hand quadrant, correct?
Mm-hmm. Yes.
The far left window, that's your bedroom window.
Yep.
Is that right?
Yep. The two of them.
So on January 29th, you had two bedroom windows on the left side of the house that were facing the front lawn where Mr. O'Keefe's body was found, correct?
Yes.
You're aware that Ms. Reed, Jennifer McCabe, and Carrie Roberts arrived outside your property around 6:04 a.m., correct?
Yes.
Did you hear any fire trucks that morning?
I did not.
Did you hear any ambulances?
I did not.
You didn't see the flashing lights of emergency vehicles outside your bedroom window?
I did not. My blinds were shut. My curtains were closed. I did not see anything.
Some pretty good bomb out
Testified
curtains then.
The very first thing you remember was Jennifer McCabe waking you up in your bedroom.
Yes.
So I'm sorry, just to keep track, are we going to take this down now, Ms. Little? Or we can keep the lights on? I just want to keep track of that.
Yes, ma'am.
Okay.
Thank you.
Okay.
What time was that?
I thought it was somewhere between 6 and 6:30.
May I have a moment?
Sure.
If I told you it was around 6:45 based on video surveillance footage, would you quarrel with that?
If that's what you say.
Okay. Does that sound about right to you?
Yep. I initially from the beginning just said 6:30. I wasn't quite sure.
Ms. Albert, what about the 2 calls that you received from your sister at 6:07 and 6:08 a.m., which were answered?
I never answered any phone calls from my sister that morning.
Whoa.
You're aware that the Cellbrite records indicated that you answered 2 calls from your sister.
Objection, Your Honor.
And 6:08 a.m.
The objection sustained.
Your Honor, may I approach the witness?
Okay.
Oh. Whoa. That's a pretty bad inconsistency right there, if that's true. I think so. The reason why that one was sustained is because of a speculation objection. She's referring to the Cellbrite data that came from her phone. That she may not have necessarily seen the Cellbrite data to know that it actually says that. So what they need to do is put that in front of her, and review that and say, do you recognize, does this trigger anything for you? Do you recognize this? Otherwise they can just refer to it. She might say, no, it doesn't trigger anything. It doesn't remind me of anything. And, I still stand by what I said. I never picked up 2 phone calls. Then they're still going to have an expert that's going to testify to the Cellbrite stuff. And they'll say, yep, this is what this shows. It's what it reveals is the Cellbrite technology, blah, blah, blah.
Ms. Albert, you received.
If I could just see what's being shown to the witness before. Thank you. May we approach?
Okay. I'm going to take that.
Time travel.
Please, Ms. Little.
Okay.
All right. So let's mark 1 for identification, please, Ms. Little.
Thank you.
Okay, and you can give it back to Ms. Albert,
Thank you.
and you can go back and ask a question, and let's see where we go with this, okay?
Ms. Albert, do you recognize this document?
Recognize it?
Do you know what it is?
Well, yeah, I see what it is.
Does it refresh your recollection as to the 2 calls you received on the morning of January 29th?
It says here 2 calls were
With-
placed.
Okay, don't read it, but you were asked a specific question. So if you could answer the question, please.
So there is this proper procedure that has to be followed because she's refreshing her recollection. She's using this to refresh her recollection about 2 phone calls that she supposedly received on the morning of January 29th, 2022 between 6:07 and 6:08 a.m. So she's got to just say, yes, this does refresh my recollection, or no, it doesn't.
Does that refresh your recollection to the 2 calls you received from your sister on the morning of January 29th?
She may have placed those phone calls to me, but I never answered them.
You received a call from Jennifer McCabe on January 29th at 6:07:42 a.m. that lasted for 9 seconds, correct?
Ooh.
She may have placed a phone call to me. I never answered it. I never spoke to her that morning.
You also received a second call from your sister at 6:08:17 a.m. that lasted for 7 seconds, correct?
Objection.
Go ahead and answer that.
It says that, but I never answered a phone call from my sister Jennifer that morning.
Then why does it say 9 seconds and why does it say 7 seconds? That's very specific. And Cellbrite, those tend to be pretty accurate. Like that's pretty good data for the defense then.
You're aware that cell phone companies have what are called tolling records, correct? That show if there's
And the question about like could that be voicemail, Kayla Myers? No, because it would be marked as a missed call. It would be marked as a missed call, and then there would be a voicemail that's recorded. So that would look different.
voicemail or something of that nature.
Objection, Your Honor.
Sustained.
Ms. Albert, it's your testimony here today that you never spoke to your sister that morning.
I never spoke to my sister on the phone that morning.
Who else was in your bedroom that morning?
Me and my husband.
You
It was the
Brian
dog.
Albert were the only two individuals who could have answered those calls that morning, correct?
We're the only two people in the room. besides the dog.
And at 6:07 a.m., someone had a 9-second call with Jennifer McCabe, correct?
Objection.
All right, sustained. And you've got more for this witness, I imagine, Ms. Little?
Yes, Your Honor.
Okay, so
Yeah.
we'll take the luncheon recess, folks. It's 1
Hey,
o'clock.
there we go. We reached lunch. Okay. So, all right, we're gonna get some questions, and then we're gonna end this stream. It's going to join right into other
Goodbye.
stream.
Okay.
Let me make sure that goes public because it is currently unlisted. Okay. All right. So yeah, there's an afternoon stream that this is gonna go into. But first, we've got to answer some questions here. Let's try to get them quick because we've got like 30 minutes until lunch starts, and I've got to take the dog out to pee. Speaking of dogs, our dog needs to go. Link Journey. Is Nicole Albert the Albert who asked Google how long to die in the cold? That was apparently Jennifer McCabe. Supposedly, maybe not, according to the prosecution or something. We're gonna get to that later.
I think that's from someone else's.
Mackenzie Robite. We are
Madam
going
Court Reporter,
to.
do you need me for anything? Okay.
All right. So yeah, we're not gonna miss anything. I'm gonna hit this right to live. Okay. And I'm gonna pull that off screen. Mackenzie Robite, Legalbytes. If they had all left the house allegedly after the victim had passed shortly after midnight, according to the prosecution, then how did no one see him outside? It's an excellent question. It's an excellent question. And that's definitely one of the big points for the defense. Prosecution is going to try to explain it. I think those photos that we saw earlier are going to maybe help to do that. LK Right, Dan, Legalbytes, the female attorney must be objecting to trigger the witness. Oh, we got that. I answered that earlier. Tish, Legalbytes, off topic. Could you consider making legal commentary on Fiona Harvey? She's been identified as the woman in Baby Reindeer Netflix show, and she just made an interview. She is painted up as a stalker in the show, which is said to be based on a true story, and she's now suing Netflix and the show creator for defamation. She is or was a lawyer. Let me write down the name. Well, Baby Reindeer I know is familiar to me, but let me just make sure here. Fiona Harvey. Thank you for that. That is an excellent recommendation. I'm going to note it. I have heard about it. I've heard about this issue, and it's one of those that I think is probably worthy of a video. So thank you for that. Geek EH UK is testifying as to what you yourself personally said hearsay. If so, I don't get that. Is it just a context problem from only hearing half conversation? It is what was I going to say? It is in fact hearsay because it's still an out of court statement. You know, unless it's being offered to prove, like, you know, I told this to someone else, you know, to get a rise out of them, or to get the, you know, if it has to do with the effect on the listener, then it's not hearsay. But yes, statements that you yourself have made out of court can in fact be considered hearsay. MZ, thank you so much for gifting one Legalbytes membership. Amanda, you have been gifted a membership by MZ, so welcome back. I think welcome to Bike Club. Welcome back to Bike Club. Very happy to have you here, have you back. And I hope you can join us tomorrow for our members only live stream. Alrighty, Flash Fan 85, Legalbytes. Do they still do jury views? I thought that was a classic trial thing. No, they still do site visits. They absolutely do site visits. Stephen Horton, when the jury visited the house, were they able to walk around, especially up to the doors of the house, to see how well someone would be able to see him from there? I would think so. That's got to be a one of the reasons for doing one of those site visits is being able to go and observe from these various angles to determine what's likely, what's unlikely, what's more likely, what's less likely, all of those kinds of things. So I would imagine so. However, I do not know, in fact, what they were able to do and see and all this kind of stuff at this, because I kind of glanced at the stuff about the site visit. I saw some posts on Twitter about it from journalists who were able to go and kind of observe. I know that they had to stay away from them. They couldn't get within a certain distance. But I would imagine so. I would imagine they would be able to check that kind of stuff out. Rebecca Anderson, Legalbytes, the property is on Redfin Property Sales. It is also on Zillow. I actually was able to see it on Zillow. I saw the how long it was on the market, what it sold for, all that kind of stuff. I looked at all of that stuff before because that was an interesting thing. I've got realtor parents. So that kind of sort of a dispute and that sort of question is interesting to me. So yeah. Orlane Tremblay question here. Is there any reason that the prosecution would try to purposely lose their case? I mean, there are wonky reasons why people could do all kinds of things that are maybe improper, but I will say that would be improper for the prosecution to do that, because as an attorney, whether you are prosecution, defense, or civil litigator, or even not a litigator but somebody who is a transactional attorney, you do have a professional responsibility, duty to zealously advocate on behalf of your client. So the client is the state. He's got to represent the case zealously. So that would be a problem under professional responsibility requirements. Larry Huffin question, or Huffine, sorry. Question: is it a known strategy to flood the jury with useless, repetitive evidence that goes nowhere? Could he be doing this to bore the jury to tears to affect their attention? It's a bit excruciating. He could be. I mean, sometimes that can be a strategy, is lull them to sleep, go over the stuff that's damaging. But then what's the point in going over the damaging stuff anyway? Because then if the cross examiner brings it up on cross examination, if the jury wakes up at that point, that's their first time hearing it. It kind of has the same effect. You know what I mean? So usually, regardless of what the testimony is, you don't want the jury to be sleeping when you're the one giving it. When you're the one on the other side, maybe you do. Maybe that's helpful, for them to be sleeping during important parts. But usually for your own case, you don't want that. Orlane Tremblay question: what if any law school taught this guy? I actually don't know. I have no idea. I assume some law school. I assume he's got a lot of trials under his belt too. And I think the what if any's are probably a bit of just a habit that he's just sort of developed over the years. I'm not necessarily the best public speaker, especially with like live streams and stuff like that. I've got a lot of ums and uhs that I've tried to work through, and I'm better than I used to be, but I'm still not perfect. But there you go. Everybody's got their stuff to work on. So I think that for him, the what if any's are kind of one of those fillers. Firefly Bakery Sweets. Question: how are you and baby feeling? I hope you are both feeling well. Thank you. Legalbytes has been kicking during this live stream. So that's great. Everything is wonderful. Thank you so much. Mike Olson, Legalbytes question: this trial is interesting, like a couple of other trials that was broadcasted the last couple of years, but do you think we will experience a trial like Deputy Heard in our lifetime? And I think this is a similar question that you asked: a trial as eventful and commercially fun as Deputy Heard in our lifetime. I have no idea. That one definitely felt like a once in a lifetime kind of trial for sure. Who knows? There's all kinds of spice that can come up in these cases. My mic is muffling. Let me see. Let me check if something happened with my. No, it's still my microphone here. It's not my AirPods, so it should be okay. Let me know, folks, in the chat, if there's an issue with the sound of my mic, or if that's a one-off kind of thing. The Lucy on Legalbytes defense already talked about the Ford Edge in opening with the city snowblow guy. Her questions were in regards to Nicole intentionally not mentioning her family had one. No, for sure. I definitely got that. I missed it in the opening statement, or at least maybe I forgot that was in the opening statement. But yeah, no, it'll be interesting as more information gets fleshed out later. My impression from that cross-examination is that they just wanted to kind of plant that in the jury's mind of like, hey, you don't like this little factoid. We're going to go into it later. I think that's more what they were trying to do there. Alrighty, Desiree Morgan, is it normal to have common witnesses? I thought that attorneys called in witnesses who are on their side to help prove their case. By the way, I love your coverage and channel. You are so good. Thank you so much. I really appreciate that. And on that note, if you guys are enjoying it, please do like the stream to help to give more exposure of these streams to more people on YouTube. But thank you so much for the compliment. Is it normal to have common witnesses? Yes, it is. It is common, because even if somebody is adverse, you can always call an adverse witness. You can always call someone who is not really great for your case. Sometimes those can actually be kind of fun to bring on as a direct examination, because you can call them as a hostile witness and basically do a cross-examination on direct examination. It's kind of a wild thing when that happens. but yes, when you have crucial testimony that you want to get out through a particular witness, you want to have them on your list, whether they are, they have an interest aligned with you or aligned with the other side. You want to have them on that list. It is very common to have that. Sandy Maverick is convinced that you're there solely to love her during streaming. It is so true. And on that note, also, there's a lot of that in today's recap the recap from day 8 that was just posted a couple hours ago. So, when we do take a break from this stream, definitely check out the recap from day 8, because Mavi is all over it with all kinds of chaos agency shenanigans from beginning to end. It's pretty funny. The Lucian question: can witness hear these sidebars too? Looks a small enough courtroom. A lot of times what they'll do during trials, not every courtroom has it. Probably this is an older courthouse, so maybe not. But a lot of these cases, especially the high profile cases where they know that there are going to be cameras in the courtroom, what they'll do is they'll have a white noise machine, essentially, that just kind of blasts the whole room with white noise. And that's what they'll do so that no one can really pick up what they're putting down. They can't hear what they're saying during these sidebars. So, and I have noticed that they do seem to go kind of to the opposite side. So I don't know if the witness can hear them. It is a small courtroom, but maybe they've got some methods for keeping things out of their earshot. Mike Olson question: how did your small channel become this good for these trials? In all the others, your voice is lost with all the noise. I'm so happy for this live. Yes, I kiss ass, but on live. Thank you so much. That's very kind of you. And let's see here. I've got to get this over here. So I've covered some trials. Let's see, trials that I've live streamed so far. We've got the Rittenhouse trial that I was on someone else's channel for. Deputy Heard I had on my channel. Gwyneth Paltrow ski crash trial. I live streamed this, starting with the second half essentially of that one. I've been doing the Menendez brothers, in classic trials. So I've got some experience with live streaming these trials, and then otherwise covering and recapping some others as well that didn't have cameras in the courtroom. So it's fun. I love explaining this stuff. I love sharing what I know, and there's also sometimes stuff that I'm learning as well. My experience is primarily in civil litigation, and sometimes there's some weird stuff with criminal cases that I later realize, like, oh crap, I got that wrong. And so I try to flag that for folks when I give bad information. But yeah, it's a work in progress, but it's fun. Mike Olson also: what would you vote in your own poll that all of us have voted on? Guilty, not guilty, or need more info? If you put a gun to my head and said like, which way do you lean? I think there's a lot of reasonable doubt in this case. A lot of reasonable doubt. I'm keeping an open mind. I'm willing to hear reasonable explanations from the prosecution. I'm listening for them. I'm hoping for them. So far, they haven't served up enough, and that's the job of the attorneys in this case, is to make that easy. I shouldn't have to be like begging for these explanations from one side or the other. So that's yeah, I don't know, but if let's say they ended the trial now and they said, hey, jury, vote, I would lean not guilty, because the prosecution has not yet proved this case. They still have trial though. They still have plenty of trial time to do it. Purchases made simple. Someone in another chat said they actually talked to Colin at a bar, was sloppy drunk, and admitted to unaliving John O'Keefe. Now that is a wild statement. Absolutely. But keep in mind that is the definition of hearsay, not necessarily the admission, if that's what happened, but the person saying that they heard him saying that. That's the definition of hearsay, saying this is the thing that's true. If that person were testifying, well, actually, if that person were testifying in court, then that would be an admission. But that we got some hearsay issues. But that's an example of like how we can't necessarily trust that, because we don't know who that person was. Are they lying? You know what I mean? Dolly Hood question: have you been to the courtrooms in Massachusetts? Are the ones in Austin much larger? Howdy ho from Austin. Well, everything's bigger in Texas, right? But I've actually never been to Massachusetts in general. One of these days I've done half and full marathons. It's been a while, but one of my like lifetime bucket list goals has always been to work on my marathon time and qualify for the Boston Marathon. And I would love to do that. Boston also is just a great town for history and all that kind of stuff. American history, especially the first Boston Tea Party before this trial, right? So anyway, but I don't know. I don't know. But courtrooms actually do vary, all across the country, within each state and outside of each state. So I don't know. I don't know how they compare. Rouse J 1199, would the prosecution try and purposely get a mistrial if they see they won't win the case so they can retry it? And I think that would be improper. I don't think they. I mean, would they prosecute? Hey, prosecutors have done all kinds of things, whether proper or improper, and that's true of every kind of lawyer, really. Prosecution, defense, civil litigators, transactional guys. That's true. There are human beings in every profession and in every niche within the profession, I guess we could say. So, could they try? Would they try? I don't know, maybe, but should they? No. JP Eagles and Cats, go walk your dog. He needs some Legalbytes time too. Yeah, she does. Yeah. And if we need another 5 minutes when we start the second stream, I hope you guys will afford me that just to get her out. El Borate, Legalbytes isn't direct harder since you can't lead. I think it can be. It's sometimes easier because of the fact that the witness that you're direct examining typically is a friendly witness. And so they kind of want to help, they want to help tell the story. They want to participate. Whereas when you are cross-examining, it's like you have kind of an unwilling participant. So that's where things are a little bit more difficult. But of course, like you said, you can lead a cross-examining witness. So that is very different. So, there are upsides and downsides to both, but with practice, either one becomes easier. I'll say that. Family man Donnie, apparently Karen was assaulted in the courthouse. Oh my God, are you serious? I guess we'll check Twitter to see if that's the case. But if so, that sucks. I don't care how you feel about this case, whether you are pro prosecution or pro defense. That sucks. That really sucks. All right, folks. Ooh, I gotta go. All right, guys. Ooh, he has thoughts. Okay, I gotta go, guys. We are gonna go into the next stream. I'm gonna put some links and all that kind of stuff. I'll see you very, very, very soon.